that's fine. They drop, when I put it there, they drop it. So.
Yeah, that's why I said putting that one over there too.
Hello.
No, I have my key right here. I have my key, but I'm not gonna let you get it. Diana, let's do my name. Okay. Yeah, how about it?
Yeah, I have that very easy.
Oh, God.
I want to go back to jury duty.
Oh,
I'm gonna be quiet. I'm gonna keep my head down and sitting back in the row. Maybe I get selected.
I had a friend who was on a. I don't know if they were in school. It might have been on this, but this was several years ago. Though. He was on a trial that ended up having like 2.5, almost 3 years. She was like, "You left."
Wish they would have me though.
So we were laughing when they were saying, yeah, I get sick of you on our channel.
Yeah. And that would be funny. To have it on for a long time. Like after.
all right, Rashawn, it's Tuesday.
It is one day closer to Friday.
Yes. Yay. All right, I'm going to call the docket. When I call the docket, you need to stand, let me know you are here. Otherwise, I'm going to assume you're not here, and a warrant may be issued for your arrest. And everyone, you need to silence your phones. In custody, we have Joshua and Zadua, Alexander Rodriguez, Jacob Villalobos. Is he in custody?
Yes, Judge.
Eric Michael Jones. Eric Michael Jones. Jose Castaneda. Jose Maria Castaneda. Ace Cantu. Sergio Morris. Sergio Umberto Morris. Alexander Castro. Thank you. Jocelyn Chapa, custody. Tyler Ashbaugh. Robert Andrade, custody. Edgar Aguilar, custody. Sarah Elizabeth Gutierrez. Thank you. Excuse me. You shouldn't be on the front row unless you're late. Denise Thomas. Denise Marie Thomas. Eric Kelly. Brenda Rodriguez, that's by Zoom. Sandy Garcia. Sandy Garcia.
I think she's in jail.
No. Otilio Espinoza. Thank you. Elisa Hernandez. Dennis Johnson. Anthony Villarreal Jr. Francisco Sotelo, custody. Christian Dunbar. Christian Theodore Dunbar. Eric Kelly. Johnny Trevino. Seth McDonald, Christopher Weezer, custody. John Salcedo. Marissa Magana. Marissa Magana. Ruben Solano, custody. John Paul Pena. Mary Diaz. Darius Murphy. Thank you. Dana Waters or Waters. Dana Waters. Taj Davis, custody. Stephen Carmona. Deputy Laura, Deputy Mejia, a lot of people are going to be going into custody today. And RC Curtis by Zoom. Anyone who came in late or your name wasn't called. We'll start over here. What's your name? I'm sorry, what?
Eric Jones.
First row, sir.
Yes.
Dirkland Davy.
What?
Dirkland Davy.
Do you know who your attorney is?
Monica
Monica who?
Guerrero.
All right. Do you know your case number, SID number? It should be on your sheet of paper at the very top.
1194194.
That's probably the sit, Judge. I'll look it up.
All right, just have a seat. We'll get with you. Anyone else? All right, everyone. We're going to be starting a jury trial today. So if your attorney is not here by 9:30, you have the court's permission to step outside, use the phone, call your attorney to get here. Otherwise, what's going to end up happening is you're going to come back, and it may be inconvenient for you, but you will come back and your case will be heard before this week is out. So everyone, attorneys, these are the rules. I find that sometimes I have to repeat the rules because when I don't, people start doing different things. So once I say these rules, if you want to tell your colleagues these rules, you're more than welcome to do so. 1, we have a new court reporter. Court reporter, please raise your hand. She does not know you all. I am sure when you're making a record, you would like for your name to be in the record. So when you go up to the bench, if you have a card, give her your card. And some of you attorneys, I know you've been around for a long time, so you no longer carry cards because you're like, I'm famous. I don't need my cards. People know who I am. So if you will come up and introduce yourself to her, and when I say introduce yourself to her, don't come on this side and say, oh, my name is, and whisper your name, because guess what? She can't hear it. So just walk over to her and say, hi, Maria. I'm attorney so-and-so for client so-and-so. That would help us move things along swiftly. And remember, when you come before me, please don't whisper. Allergy ear is causing me problems. So if you want me to hear what you're saying, please speak up. If you want the court reporter to hear what you're saying, please speak up. What I've discovered is people are very loud in the gallery, but then when they come before the bench, they whisper. I don't know why that's the case, but let's not do that today. Number 2, do not approach the court unless you have conferred with your client and conferred with the state. If your client is in custody, yes, they need to be brought out because I'm sure they want to know what happened in their court today. And let's make the deputies not have woken somebody up, because I believe they wake them up at 3 a.m. to get them to court here at 9. Let's just not leave them back there without knowing, hey, why did you disturb me? I was having a great dream. And then I get brought over to court and nothing happens. So once you have done that, you need to ask the deputy, and the deputy will have your client brought out. Once you requested your client be brought out, do not leave the courtroom. The reason being is because for security reasons, the deputy can only have so many people in the box. I'm not in charge of security, but I think we all want a pleasant courtroom experience. So in order to do that, once you request your person, don't leave. If you leave, you are being inconsiderate to your colleagues. Don't do it. If your client wishes to speak to the court in a language other than English, yes, we need an interpreter called down. Please do not tell me, oh, I speak the language. That's not the point. Legally, we need an interpreter to be called down. Once you've requested the interpreter, do not leave because we have a limited number of interpreters and they will come in, do their job, pop out, go to the next courtroom. Now, when you are ready to approach the court and you have done all those things, just come up to the coordinator or the clerk, ask them to pull your file. Have a seat. Do not get in a stare down with me like, I'm waiting, because this is what's going on. The files are placed here. I will call you in the order in which I received your file. The only exception to that is if you need an interpreter because we have a limited number of interpreters. The other thing, COVID has been knocking on people's doors and they've been saying, hi, this is COVID. May I speak to you? Darryl Harris. And guess what has happened? People have been opening the door. Hey, I'm here. I'm Darryl Harris, Mr. COVID. You want to come in? So COVID has been going around. Let's not breathe over each other. This is what we're going to do. And attorneys, again, I need you to be considerate because other attorneys who follow the rules say that you all have not been considerate to each other. Criminal trial division files are here. Family violence files are here. Grab your file. Take it to the table. Sit it on the table. Guess what? They're going to call you in the order of appearance. The only exception I see happening is when people are not being considerate to each other and they just start rushing the attorneys and standing over them. Let's not do that because the other attorney who's following the rules can tend to get a little bit angry, and we don't want angry people here today. Now, there's another sign that people don't pay attention to. See the sign on the computer for the coordinator? It says, do not approach the coordinator, do not approach the clerks, do not approach over here when we're on the record. And you will know we're on the record because I will have called the style of the case. I find that sometimes when you explain rules to people and why they're in place, they have a better chance following it. I don't do arbitrary rules in this court. The reason why that's in place is because when people are before me, and attorneys, when you're before me, you want me to hear 100% of your argument. Your client wants me to be 100% focused on their case. If there's conversations and discussions going over here, guess what? I'm a woman, we multitask, but 1% of my ear is over here. So let's not do that. It is Tuesday. We're closer to Friday than we ever were before. So we're going to confer. We're going to be nice to each other. We're going to be kind to each other. So everyone, please confer and follow those rules.
Oh, for sure.
All right, is there anyone else who came into the courtroom late? What is your name? I'm sorry, what? All right, and what is your name? Denise what? All right.
Okay. No, no, you first. Yeah.
David Barton and Ashley Joe.
Oh, that's right.
I know, mine took like.
Oh, yeah.
All right, on Alexander Castro State, I still don't have the motion in the file. Does anybody have? All right, thank you.
Judge, you said you wanted other motions, there's one from us, we
Sure.
filed it, we've not got the stamps back on it, so I just brought it anyway. I can
No.
go to clerks if you want,
No, this is fine.
I've given a copy to state as well, Judge.
All right, sure. If you'll, I'll keep this, but do you have an extra copy for the clerks?
I can give them my copy, Judge, if you want.
No,
Once you've
just, what I'll do is I'll go off of this one. And then what I will do is, once I've read over it and made my rulings on it, I'll have them file stamp it.
Okay. It's been filed anyway, but
Okay.
it's, you know, it's in the system waiting to,
Wherever.
whatever it comes down.
All right, so guys, just let me read this real quickly and then I'll call you up. All right, the parties on Castro, just let me know when you're ready to proceed. All right, Mr. Hilliard, are you ready? Oh, no problem. Can you have your client come up? And is it easy for you all to do this standing or you want to do it seated?
Just standing. Judge.
Okay. And these are the only two motions that I need to hear?
Well, yes and no, Judge.
Okay.
There is an issue that the scheduling issue that I feel that in the abundance of caution, I need to bring up to the court, but we're ready to argue our motions, Judge. It's whatever order you want to
Okay,
take.
all right, we'll take this up first then. We're gonna go on the record. Court is calling 2022 CR 11862, State of Texas versus Alexander Joseph Castro. Can I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Sorry, Judge. Gary Hilliard for Mr. Castro.
And are you Mr. Castro?
am Mr. Castro.
All right, so let's first take up defense's motion in limine because I believe that will be a quick one to take up. State, have you had a chance to review the motion in limine?
Yes, Judge.
All right. And State, do you have any objections?
Yes, Judge, to section 1 and to section 2. Both of them talk about impaired and, the defendant consuming alcohol. In our indictment, one of the manner means is through the introduction of alcohol. We're not alleging intoxication, but that is one of the manner means that we were trying to go with recklessness. And so the state feels that if we have to be limited in whether or not we can question that the defense has been on notice, well, that would limit us in the presentation of our case.
All right, just one moment. Let me pull the indictment.
first, second, third, thanks.
All right, so state. My understanding then is you're not trying to say that the defendant was intoxicated?
No, Judge, it's just that one of the ways that he was reckless was that before driving his vehicle was that he was consuming alcohol, that he admitted to consuming alcohol.
All right. And it is in the indictment, counsel. So what is your argument to their argument?
So the first part, Judge, part one is our objection to we anticipate the state is gonna try to bring evidence that Mr. Castro was intoxicated. So the first bit is intoxication, Judge.
All right, so let's stop there.
Number one is intoxication.
All right. So are you going to try to say that he was intoxicated at the time?
No, Judge, because he's not charged with intoxication manslaughter, he's charged with manslaughter. It's just the fact that he was consuming alcohol and whether or not it could have played a factor in what happened.
All right, so defense and state. Then with regards to the motion in limine, if you are going to seek to establish that he was intoxicated, y'all need to approach before that's done. But if the only issue is going to be that he consumed alcohol before driving, then the court is going to allow that. And it appears, defense, that your main concern is that you don't want them to seek to establish that maybe your client was intoxicated.
Correct, Judge. That's the first part.
All right.
Judge, if I may, can I address
Yes, you may
the second one?
continue.
So, Judge, the second paragraph is obviously, and of course, we object to it in the indictment, but we understand it's part of the manner and means that the state is going to try and establish. One of the standards that the state we anticipate is going to try and prove is that Mr. Castro was impaired through the introduction of alcohol into his body. Now, the problem with that, Judge, it's confusing. It hits almost everything in 403. It's an improper legal standard. It's not defined in the code. It's not defined in case law. So we would be asking the jury to make a factual determination based on a made up or non-legal term. So it's confusing and it would ask for speculation. The consumption we understand is a court's ruling, Judge. That's fine. But this impaired word is not a legal word. And so we object to any evidence about impairment.
All right, so what happens in courts where there are not legal definitions for words? Do we not use them because there's no legal definition?
I think that's the way that courts, it's defined through case law, Judge, and it's normal usage. But the reason that we object to the word impaired is because impaired is kind of synonymous with intoxicated for a layperson. We know as attorneys that according to the code and law, case law, intoxication is very well defined and it's clear. It's under 4904 of the penal code, but impairment's not. And so impairment in a juror's mind, despite the court's instructions and explanation, could still be the equivalent of, oh, he was intoxicated then. So it's the same thing. It's like saying, using the word drunk.
But isn't that something to handle through cross-examination?
Well, that might be how the court rules, Judge, and, but that's our argument, Your Honor, and we'll leave it to the court to rule.
All right, defense. I'm sorry, state.
And Judge, again, we disagree. Again, the jury would be able to, just because it's not legally defined, they can use the normal meaning of the word. Again, that's something that it's through defense and statements and just the circumstances around what happened. That's at least something that they can make a determination. And again, we're not trying to say intoxication, but again, it's impaired. That's something that, again, that word may not come up.
All right, so with regards to the balancing test on whether or not that line of questioning should be allowed, I'll need to make that determination at the time evidence is presented. So state, before you have a witness testify that you believe or they believe that Mr. Castro was impaired, we'll just have the jury step out for a moment so I can hear the question and make a ruling with regards to 443. I'm sorry, 403. All right. So on number one, I believe that's been settled, so you can ask questions in regards to whether or not alcohol was consumed. Number two, you'll need to approach
And Judge, just for the records, number one was more intoxication, number two was impairment, and number three, I apologize, that was consumption.
All right. So, well, number one, that's been granted. You're not going to try to establish that he was intoxicated. Is that correct?
Yes.
All right. So if something changes in regards to number one, then you all have to approach and we'll handle that outside the presence of the jury. But number one, that will be granted. Number two, you'll need to approach. And number three, defense.
Again, I think I know the court's ruling. Again, it's a 403 argument. We'd ask the court to make a balancing determination to see whether any evidence is the risk of confusing the jury, the issues, misleading the jury substantially outweighs any probative value at the time.
All right, well, number three appears to be that you're not wanting the state to mention that Mr. Castro had allegedly consumed alcohol.
Correct, Judge.
All right, well, that's in the indictment that they're stating that he consumed alcohol. I will, you want a 403 balancing test. Here's the thing, I can't do a balancing test until I hear the evidence, but I will make my ruling when I hear the evidence. But defense, what I'm telling you is the consumption of alcohol is in the indictment. And the state, in their argument, said that your client admitted to consuming alcohol. Whether his admission that the state is alleged he did comes in or not, that's another question. But I really don't see at this point in time how that would be prejudicial.
Again, if I may supplement that, Judge, I'm sorry, I should have said it before. Case law has established that consumption of alcohol is not illegal. And so to allege that as that consumption of alcohol is a manner of means on its own that is equivalent to recklessness is misleading in itself. And that's my argument, Judge, and we respect the court's ruling.
Okay. All right. So with regards to the consumption of alcohol, state when you are ready to ask a witness whether or not Mr. Castro admitted to consuming alcohol, or however you wish to have the evidence presented that alcohol was alleged to be consumed by Mr. Castro. Just approach. And for that part, I'll have you all come forward and I'll do a balancing test.
Yes, ma'am.
All right. So far, does everyone understand the court's rulings? All right, then let's move on to number 4, prior convictions.
Judge, the state's in agreement. The only caveat would be is that if the defendant does take the stand, if there's anything that comes up.
All right, so with regards to prior convictions, if anyone believes that they should be allowed to ask questions about that, just approach before you do so. Extraneous offenses?
Same thing, Judge, if there's any sort of opening the door or that, the defendant will take the stand. That's.
All right, just approach beforehand. All right, defense, do you have, I know you have the time motion that you wanted to talk about, but before we get to that, any other motions other than that?
That's all, well, for now, Judge, that's all we needed to be ruled upon before we pick a jury. That's it for now from the defense. Thank you,
All
Judge.
right, so then we're going to move on with the state's motion, and they want to have the jury view evidence outside the courtroom. Defense, have you had a chance to review the state's motion?
I have, Your Honor.
All right, defense, are you in objection?
I do object, Judge. Yes, we do.
All right, I'll hear your objections.
Your Honor, and I've got 2 cases for you.
Okay.
And I'll give the state the it's Andika versus state, and one of the cases is one.
Just one moment. For the court reporter, it's Andika, Andika, the state. All right.
Thank you.
Yes.
So thank you, Judge. So we do, we've seen the state's motion and we object. And based on the case that the state cites in its motion, which is Mauricio versus State, and I can give you the citation if you need it.
Yes,
Um,
and here's the thing, everyone, when you all are saying cases, because we read case law all the time, court reporter doesn't read case law all the time. So if you all could pronounce it and make sure that if you want your record to be clear, make sure that you spell the case to the court reporter and whatever site you have.
And it's Mauricio versus State, Your Honor, and the citation is 153 Southwest 3rd, 389. And this is the state's own case that they cite. And basically our objection, Your Honor, is that what the state is proposing is an improper demonstration or a misrepresentation of the scene as it happened on the evening. Now, I don't know what the state is trying to prove by bringing these vehicles here. It's certainly overly prejudicial. It will be misrepresenting the state as it appeared on that day, because obviously you can't recreate, obviously the court doesn't know this, 281 North in the space between the two vehicles where the accident crash site was over a quarter of a mile at least. It'll be a misrepresentation of the crash. And it goes to what the court says in Andika, in the case you've got there, Judge, and I highlighted it, that the court, one of the things that the court can consider is the nature or the deterioration of the scene or the items to be viewed. Now, my understanding, these vehicles have been kept in, what's it called? At the pound, the SAPD pound, and they've been there for 2 years. So the condition that they are in today is not the condition that they were in 2 years ago. They've been outside, it's grounded, and they're outside. So they would have been exposed to the elements. So they will not look today like they did 3 years ago. And the case that the court, the state cites, Mauricio, in that case, that was a demonstration. Mauricio was a demonstration where, and this case isn't Mauricio, this is a case where there was an accident. And we're just going to be looking at the vehicles. Now, what the case law says is, one of the things that the court consider, Your Honor, is that whether that evidence can be obtained from more traditional means, such as photographs and videos, which there are in that big box over there, there are hundreds of them.
Okay, so let me just stop you a little bit because I like to take things one step at a time. So it appears your first argument is that the state may be seeking to recreate the scene on 281, potentially.
Possibly, that's correct, Judge.
State, are you trying to recreate the scene from 281?
Judge, the reason why we gave notice to both the court and to defense is that you could make a determination as to how we present the evidence. If you say that we need to try and recreate it as best, we can try that. If it's just we bring the cars here and we show them, that's up to the court's determination.
But no, my question is, are you seeking to recreate the scene from 281?
No, Judge, because as defense counsel mentioned, that is a very large stretch of highway. What we would do is trying to just present the car so that they can see the condition that they were in.
All right. So then you're saying that you want to just present the cars so that the jury can see the conditions the cars were in.
Yes, Judge.
All right. So then his next argument, and correct me if I'm wrong, he's saying that because the cars have been at the pound in the element, and I don't know if they've been in the element or if they were covered or not, but he's saying cars have been at the pound for over 2 years in the elements. Are those cars in the condition they were in at the time of the alleged crash?
My understanding, Judge, is that they've been left grouted in that no one has gone in and done anything to the cars.
But have the elements changed?
My understanding, Judge, is that they've been covered in plastic and that they have been covered.
All right. So the first thing that the court will need to know, and there will need to be witnesses, I'm assuming, for this to say that the cars were protected from the elements.
Yes, sir.
Because I can understand if the cars were not protected from the element. I'm not a vehicle expert, but I know a little thing about vehicles. If you leave them in the elements, what will happen? Rain, hail, whatever. So I will need to hear from someone. And I don't know if defense is aware if the vehicles have been covered, if they have been protected from the elements. So I would need to know that in order to make a ruling based upon the objections you have. So the state is saying they are not trying to recreate the scene. but they want the jurors to see the state the cars were in after the alleged crash. Then the next question, based upon his argument, is there some other way to do this other than viewing the cars in person?
Judge, even looking at the photos, just due to perspective, it does create issues with recreating the scene itself. So that would be one difficulty. That's why bringing the cars themselves would be important because.
But you said you're not recreating the same.
Or just to bring the cars back to show the condition, Judge. Sorry about that.
Okay,
To where, again, just the perspective, the size, damage, things of that nature, it'd be difficult to recreate that with just photographs and with the video, any video alone.
okay. All right, so defense, they're stating that it will be difficult just through photographs to show the size, which I think we all know that photographs are not, you're not going to show if a car is, 20 feet or whatever, you're not going to bring a photograph that's 20 feet. So they're saying that the photograph will not, I guess, show it as accurately as an in-person viewing of the vehicle. I think that's their argument.
And Judge, with respect, it's not the court. I disagree with that,
Okay.
obviously, because.
Oh, no, I'm just stating.
I
what
know,
they're
no,
saying.
no, Judge, not
Yes.
yourself, but with respect to the opposing counsel, I disagree with that. It's standard in any of these cases where people know how big a car is and how big a truck is, Judge. They know that from common experience. Is there anything to be gained from seeing the actual object itself? I mean, and it's almost, it's like where does this end argument? Because if we're going to do that, then it's still an improper reconstruction. Judge, it's cumulative to as well. I mean, it's a cumulative showing of evidence. That Mr. Escobar yesterday, I don't know if that's their plan. I don't know what the state's plan is for this case. Said he was going to try and do that on Friday. Well, I'm assuming that's towards the end of their case after they will have submitted photographs. So to do that would be cumulative and it would be overly prejudicial because, and again, and I mean, cast no aspersions on the state, and I mean no offense by this, it would be done for the shock value to see the actual vehicles themselves because they're in a terrible state. And that evidence can be put into the record fairly through videos or photographs, which is the norm under the Texas Rules of Evidence, Judge.
All right, and I understand when people say that things can be put in videos or things can be done a certain way, but I'm a firm believer that people should be allowed to present their case however they want to present it. So I do have some questions. So you would be able to have the vehicles brought down
Yes, Judge.
and those arrangements could be made.
Yes, Judge.
And where would the vehicles be placed if they were brought down?
In between the two courthouses, Judge, we've reached out already to SAPD to start to give them a heads up that we're going to be asking that they be brought down. And just a time schedule, really, it's just at this point when the court would allow us to do that so that we can just give them a firm time, give them a firm schedule.
Oh,
Judge,
yes.
sorry. Jason Garahan for the record, for the state. I think my suggestion would be is if we could bring them down, no matter what, so you can inspect them if you like, the defense counsel will inspect them before we show them to the jury. And that way you can see from photos that defense counsel has, whether the elements have attached to them or anything has happened. I think that would be the most fair assessment for the judge and the state. This is pretty standard throughout the state of Texas that cars are brought in for these type of cases because it shows the amount of damage, the amount of power, the amount of speed that happened during the case. And no photo can give any type of perspective to a juror about the amount of damage. It's just like taking a bed into a courtroom where somebody was stabbed to death. It's brought in because it shows the amount of power, the amount of damage that could possibly happen.
All right, and what I can tell both parties is I'm going to hear your argument. And I was going to suggest that the vehicles be brought down because that will enable me to make a fair ruling. So everybody is, I know you're speaking what the photographs show, but I'll need to see the vehicles as well to make a ruling, okay? But I want to make sure I have everybody's arguments clear, and then I will make my ruling once I see the vehicles. All right, so the other thing is, so what information state are you hoping to gain? Mr. Garahan, I know you mentioned some things you hope to gain from having the vehicles brought down that you're not able to gain through photographs or videos, but if you could just elaborate on that, please.
Yes, Your Honor. Discussion with Mr. Escobar on this case, the actual physical evidence is brought in all the time during cases. A gun, so to say, and I know defense probably objects to a lot of guns coming in, but the fact is, this is very similar to that. It's one, in this indictment, it says deadly weapon. One thing that we have to prove that the individual used his truck as a deadly weapon. Hence, we're bringing it in, just like we would bring in a weapon of a handgun or a rifle type caliber. So actually perspective and seeing that in the physical form, one, it shows the power, the amount of energy that was used. One thing that we've alleged excessive speed, that would also be something that the jury can view, and that can only be obtained most of the time from actually seeing it in the physical form.
Anything you wish to add, Mr. Escobar?
No, Judge, I think that was very good summary of what my argument was about to be.
All right. And then counsel, with regards to your argument, the change in appearance, of course, I won't be able to see the change in appearance until we have the photos for me to see and for you to see the photos as it relates to the vehicle. And then, of course, I'll give you both a chance. If you have more arguments, once you see the photo in the vehicle, you can place that on the record as well.
And may I very briefly respond to the state's argument there,
Yes.
Your Honor, because from Mr. Garahan, and with respect, again, this is what we're talking is a crossover into expert testimony. By looking at an object, a jury of lay people can't tell the power and speed of vehicles. They can make conclusions and assumptions, but Mr. Castro shouldn't be convicted based on assumptions alone and conclusions by lay people. Normally the predicate for speed and power is laid by expert witnesses, not by viewing an object. And so we object to that. It's cumulative and it's overly prejudicial, but it's in the discretion of the court, and we respect the court's decisions.
All right, we will see, and we will see whether or not there's just a viewing of the object if the court were to rule that the objects were allowed, and whether or not testimony is taken between the Sally Port outside or not. That's something you may want to speak on if it gets to the point where testimony needs to be taken outside. And the reason why I bring that up is based upon the argument that you've just given the court about an expert.
And Judge, and to that point, Judge, in the case that the state cites gives a good roadmap of, the court having to set this up with a court requiring your point, Judge. A court reporter needs to be there in case there are comments made by anybody.
Oh, the court reporter will be there.
Yeah, and just be set up in a way. And again, but we respect the court's decision.
All right. So I've heard both arguments. Is there any? It's you're objecting. It's their motion. Do you have anything else to add?
Nothing else to that, Your Honor. Thank you.
All right. State anything else to add because it's your motion.
No, Your Honor.
All right. Then what we'll do is once the cars are brought, and I think it would probably be best to time the bringing. We can go off the record. I think it would probably be best timing to bring the vehicles is when we're close to any testimony or anything about the vehicles, because I don't want them sitting between the two buildings for any length of time.
And to that point, Judge, I guess they're going to need to have people, SAPD or officers guarding them. Not guarding them, but babysit.
I understand. Yes,
We're taking precautions on that.
yes.
Because they're not going to be admitted, obviously, right? They're demonstrative evidence, I'm assuming.
Yes. Well, I don't think the court reporter wants to take and her room will not be able to hold vehicles.
Well, I don't know what the state's intention is, Judge. No,
All right. So then you say a timing issue, counsel?
I do, Judge, and I'm sorry, Judge, but in the abundance of caution, Your Honor, I know that you will remember, Your Honor, we were here 10 days ago on.
I'm sorry, I don't
No, we're not on the record. Just go ahead.
No,
Come in,
so,
yeah.
okay, Judge, we had a motion on our motion for continuance 2 weeks ago because I was at the CLE.
Yes.
And I've got a copy of the motion here, Judge, for your, and I know you'll remember, Your Honor, I going on vacation on Saturday.
Mhm.
of this week, for 2 weeks. And the
Oh,
court,
this trial is going to be finished.
Judge, with the greatest respect, this case is that whole box. Even
Oh,
if we
no,
don't
this,
ask the question.
here's the thing. You all are wordsmiths. I know people are not going to be asking questions that do not need to be asked. I'm pretty sure there's not going to be a recross and a redirect. We've had trials in this court. And I judge length of time. Is there a video that's 13 hours?
There is excessive body cam.
But is it like over 13
You're
hours?
not playing proportions.
All
So,
right.
it is, there's three body cams that are at least 6 hours long. And then there's one body cam that's 3 hours long.
Well, let me just tell you, my salary is paid by the taxpayers. And guess what? If we need to be here on Saturday, I know nobody has anything to do. I will be here on Saturday. So we're going to get it done.
Judge, if I may, I'm actually, I've got a vacation notice on file. I have non-refundable tickets leaving on Saturday.
Oh, where are you headed?
I'm, I'm going to Florida. I'm going on a cruise in Florida.
Let me just tell you, you know what? I've heard so many bad things about cruises.
I don't
I
want
may
to go,
be
Judge.
I may be saving your life.
My wife's making me go, Judge. She'll
Oh.
kill me.
Your wife is making
She
you
is
go.
making me. I'll leave that for the record.
Oh, I can't even believe you would say, let's put that on the record. He
I'll
says
put it on
his
the
wife
record.
was making him
I'll
go.
put it on the record. She won't
Oh,
mind.
let me just tell you, this is going to be done. And you know what? If we believe it will be done, it will be done. But if we don't, then we're just putting negative things out in the universe. It will be done.
If I
You
may,
will get on your cruise. What time is your plane?
8 a.m. on
8
Saturday.
a.m. Oh, you'll make it.
Your Honor, we are going to the jury for punishment.
You'll make it.
That is, I understand what the court's saying, Judge. I'm the only one who knows really anything about this case.
You'll
from our
make it.
firm. I don't want to bake into the case any ineffective claim. I
You'll
don't-
make it.
With the greatest respect to the court had suggested originally trying it on the 19th.
No, you'll make it.
And again, I understand what the court's saying, but I just want to put it down for the record.
Oh,
that-
let's go on the record.
Oh, yeah, we're not on the record. I'm sorry, Judge.
No, because I was hearing what your vacation plans was. So, your defense, you say that you have a vacation letter on file?
I do, Judge. It's in the motion that we considered before.
All right. We will make sure that you make your,
Are there right notes
vacation.
on the back of that, Judge? I might have.
No notes. All right, so, we're gonna start jury trial today. We're gonna go all day on Wednesday.
Yes, Judge.
We're going to hopefully finish this trial before Saturday. All right,
Yes, Your Honor.
is there anything else?
Nothing from the state. Your Honor.
May I
Anything else?
briefly put some on the record, Your Honor, in
Of
that
course.
case? Then I respect the court's decision, but this is for the record, for my client's benefit and for the future, because this, I'm interested in finality of this as much as the state is and the court is. And it's about fairness to the state and the parties.
Mhm.
And I'm concerned that I have a vacation letter on file and I leave out of town on Saturday morning.
Mhm.
And I'm concerned that we will not finish this case by Friday. We have elected, or we're electing to go to the jury for punishment, Your Honor, which means getting through the state's case in chief. And they've already indicated that they're not going to bring these vehicles for this jury view
Mhm.
until Friday.
Oh, they may end up bringing them sooner. We
They
should
may,
see.
Judge, and they may, Your Honor, but that was what they indicated yesterday.
I discovered sometimes when people think trials will last long, I've had people tell me, oh, this trial is going for 2 weeks. And then they're like, oh, we finished earlier than we thought, and it's in 2 days.
It could happen, Your Honor. When we appeared last time, and I checked last night on the YouTube feed, that we mentioned, the state said it'd be 3 or 4 days, and I've said from the beginning, it's going to be a 5-day trial.
Mhm.
Your Honor, I don't know how many witnesses the state are calling or who they don't call, so we may have to present a case. And so then we're asking for the case to be finished by Friday, the jury to be charged and argued, and
Mhm.
possibly a verdict with a punishment trial to follow.
Mhm.
I'm concerned that it will be ineffective of me if I am concentrating on trying to concentrate or miss something because I'm worried about trying to rush this case through to its natural end when we could just reset it to
No,
the
I
19th.
say, concentrate on this trial because that's where we will be. All right,
I understand, Judge.
all right. So motion for continuance is denied. Anything else from either side?
No, Judge. nothing to
All
see.
right, so a jury is going to be called up. We're going to pick a jury this afternoon. And then everyone needs to be here tomorrow at 9 a.m. And we're going to start testimony at 9 a.m. Everybody needs to be ready to go at 9 a.m. 9 a.m. Nobody running in. You know, it's like a plant job. You need to be at your desk and ready to go at 9 a.m. No, we're setting up. Be on the assembly line. Even though you're getting paid at 9 a.m., I will tell you, my mother would always say, her employer would say, you're late if you're not here early. So 9 a.m., all the computers ready, everybody's ready to go. All right? And we're going to come back this afternoon at 1:30 and we're going to start jury selection.
Yes, Judge.
And you're on that, how long, can we have an hour for jury selection each side?
I mean, this is a simple case, is it not?
Nope.
All right, I'll give everybody 30 minutes. Is there anything else?
Judge, can we ask for 45 minutes? It's not a simple case. There are intoxication suggestions, there's causation issues. And the state will probably agree, there are issues with the investigation. There are, Judge. We'd ask for 45 minutes. please.
35 minutes.
Thank you.
Thank you. And counsel, if your client were convicted, it's jury for punishment. Have you filled out the election?
Just do it now, Judge.
Okay,
And he's probation eligible as well, Judge. We're
Yes,
filling out the
okay.
app right now.
and we're looking at probation or 2 to 20, correct?
Correct, Judge.
All right,
Thank
thank
you,
you,
Judge.
thank you. And counsel, you can come back at 1:30. All right. Jose Maria Castaneda. Ace Cantu. Sergio Morris. Sandy Garcia.
Present for her, Your Honor.
All right, she's not here.
I thought she was in custody. though.
Hmm?
I thought she was in custody though.
If you'll double check with them.
I'll check.
Christian Dunbar, he's by Zoom. Marissa Maganata.
We just walked in, they took into custody, we're gonna put her in the box and approach the court when the court's ready.
All right, thank you.
There was an active warrant.
All right, thank you. All right, everyone, we're taking our break at noon. Dana Waters.
She should be in. Judge, I'll talk to you about that.
All right, thank you. Stephen Carmona. All right, Mr. Cox, are you ready on Christian Dunbar?
I think he's, that's one of the.
Did y'all confirm with the state already?
Not today, but we have an offer. He doesn't want to take it.
Okay, because usually the judge was out.
All right, and Norma, could I see the file on Christian Dunbar, please?
Christian Dunbar,
And I need Brenda Rodriguez.
Ms. Dunbar. Ms. Rodriguez.
Yes, Brenda. All right, Christian Dunbar. All right, Mr. Dunbar.
Yes, ma'am.
All right. Today is your plea deadline day. Your attorney is in court. Are you accepting the state's offer?
I would like to know the offer again.
All right, your attorney will call you. Does you have his phone number?
Yes, ma'am.
All right, so just call your attorney, Mr. Dunbar.
Mm-hmm.
I'm gonna put you in the breakout room. Well, I'll put you in the waiting room. Call your attorney, and he'll remind you of what the offer is, okay?
Okay, right this second call.
I have my laptop, so I'll get on.
All right, Mr. Cox is gonna get on his laptop and he'll meet you in a breakout room.
Okay, thank you.
Sure. And when I assign you to the breakout room, please go to the breakout room, okay? Nobody
Okay.
go to the breakout room unless I call you by your name and specifically assign you to a breakout room. So, Mr. Dunbar, I'm gonna send you to breakout room number 1. You may leave.
Okay.
Brenda Rodriguez. If you can unmute.
Yes, ma'am.
All right, your attorney is actually in another county. Alphabetically, it's not ahead of Bear. He's in Williamson County. Miss Ferguson. Brenda Rodriguez. Just one moment. Let me tell you when to recall it. Can you recall her for next week, please?
Yes, ma'am, I can recall it for August 6th.
All right, you're gonna be back in August 6th.
Do you want her here
Yes,
in
ma'am.
person or?
And you'll need to be here in person, okay?
Yes, ma'am.
All right, and that will be at 9 a.m. Do you have any questions?
No, ma'am.
All right, you're excused.
Thank you. Have a good day.
Norma, what page is she on?
Page 4, Judge.
Thank you. Alyssa Hernandez.
That's mine, Judge.
I agree with the data. It's okay. Your name?
Ed Piker, PI.
Piker. All right, where is your client?
She's coming.
Okay. Everyone, please clear the center of the room. All right, what is happening with this case, counsel?
Judge, I spoke with my client this morning and last time we were here, this was set for a status on a special needs situation. She did go to Center for Healthcare Services and was interviewed. She's been asked to come back on August 6th for the assignment of a caseworker.
Okay.
Did I say that right?
Yes.
Okay.
Yes. if you're on the-
All right, and have you talked to the state about what they're requesting with this case? Are we going to see about getting her into the mental health court?
What I want to do, which would make sense to me, would be to see what the caseworker comes up with, to see what they think about her as far as her diagnosis, medicine, and then from there I can make a decision. But right now I'd be just shooting blanks.
Well, no, it'd probably be best to go ahead and see if mental health court will take her, because it takes a while for them to make that decision. And I don't want us to keep spinning our wheels.
So to do that with no commitment to actually doing it or not, until I know more.
Yes.
Okay, yeah, just to get ahead of the game.
All right, state, who is on Alyssa Hernandez? It's possession less than a gram.
I'll be judge.
All right, on this case, there are some mental health issues. So she's going to be seeing her caseworker on August 6th. And I don't know where you all are thinking about going with this case. Would you all have any objections to defense counsel having her referred to mental health court just to see where things are?
And Judge, I'm sorry, is it a less than a gram case?
Yes.
I just don't know her record. I don't know if there's
Okay.
anything pending or other.
Well, she has criminal trespass cases that are pending.
I have an injury to
So
the elderly.
elderly, yes.
That might be concerning, Judge.
Okay. All right, Ms. Ferguson, can you reset this in 3 weeks, please?
Thank you, Judge.
Thank
Yes,
you.
ma'am. Give me 1 second.
Oh, no, just 1 second. Let me give her,
August 13th.
all right, so you're gonna
That's
be,
no good, Judge.
what's the issue with August 13th?
I got a vacation letter from August 12 to August 22 inclusive.
All right, Ms. Ferguson, set it for the week of August 19th. I'm sorry, for August 26th? All right, we'll be back on August 26th at 9 a.m. And state, family violence. I don't know if you're handling the injury to the elderly case on this. It's on page 5, Alyssa Hernandez.
I don't believe we are, Judge, but please, we can take note.
All right, so whoever is, if it's criminal trial division or if it's family violence, make sure Mr. Piker has the discovery on that.
Sure, thank you, Judge.
All right, once you sign the reset form, you're excused.
And Judge,
Okay.
what is the reset for discovery or what is it?
Yes, discovery.
Thank you.
Who do I talk with to start the mental health court?
Uh,
CLO?
speak with Ms. Ferguson and she'll tell you where you need to go.
All right, thanks. Don't leave.
Mr. Piker, there you go. Please have your defendant's email address and you talk to Trish.
All right, so Trish, it's a CT.
All right, it's CTD.
I'm ready.
Marissa Magana.
President, Your Honor, she's in custody.
All right, come down.
It's Anthony Zamora.
All right, everyone, defense attorneys, before you approach, introduce yourself to the court reporter. And if you have a card, give her your card. All right, so where are we on these cases?
Judge, I've got a lot to bring up to the court's attention.
Okay,
Last time we were here, there was warrants out for Marissa. She showed up. We placed her on GPS.
Mhm.
Okay. Since that time, the location that she was staying, she got assaulted. She left. She was in communication with the GPS people. She went to the hospital. She removed her monitor. She's been doing outpatient. She's got nowhere to go now except friends.
well, when you say she removed her,
She cut her bracelet off. She had a complete melt. I'm not a doctor. I'm thinking it was pretty close to a complete nervous breakdown. I've got the documentation for the court to take a look.
all right, you'll need to talk to the state concerning that and concerning whether or not,
To place her, what we're trying to ask the court, again, she knew the warrants were there. We're here this morning. Her showing up to court is not going to be the issue. She's here all the time. Whenever the court tells her to be, she's here.
but the issue the court has is she cut off the monitor.
Yes.
So you'll need to confer with the state. And I'm going to need evidence presented as to why I should continue her when she cut off the
Right.
monitor.
The only thing I have for the court is the inpatient program and the outpatient mental health issues that she's
Okay.
having. Right
All right, you'll need to confer with the state. Who is the prosecutor on, I believe it's criminal trial division. All right, so you'll need to confer
will.
with them. All
now,
right,
Judge, and then we'll come back in line.
yes.
Thank you.
All right, Mary Diaz. All right. All right, thank you. Yes.
And Judge, just a reminder, we have victim impact on Zoom. It's gonna be several family members, but they have consolidated for one family member speaking for everybody.
Okay.
I would just like to be present.
All right, sure.
How are you?
All right, how's it going?
Good. And I have Mr. Curtis on Zoom.
Yes.
Who's that?
Okay.
Yeah, Lindsay's gonna log, tell her Lindsay's gonna log on as soon as we finish this sentencing.
All right, we're going to go on the record. Court is calling 2020 CR 11865, State of Texas versus Mary Jessie Diaz. Can I have parties announced for the record for the state?
Alan Jackson, the state.
Defense,
Charles Buck and Jim Tochi for Ms. Diaz.
and are you Miss Diaz?
Yes, Your Honor.
You entered a plea of no contest on July 16th to the offense of murder. According to the plea bargain agreement, punishment is to be assessed at a cap of 25 years in the prison. There are no applications, and of course, for murder, you're not eligible for probation. Have both parties had a chance to review the PSI report?
Yes, Your Honor.
Yes, Judge.
Any objections to the PSI report?
Not from the state, Your Honor.
No objections, Judge.
All right. Any witnesses from the state or the defense?
Not from the state, Your Honor. We just have argument.
No witnesses, Judge.
All right, then the court will hear argument. State, I'm
Yes.
assuming you're requesting that I hit the cap?
Yes, Your Honor. We feel that the 25 is already taking kind of evidence and other things into consideration. But especially after, if you read the PSI, and you've had a chance to review the report, to review the autopsy, there's just several things I want to highlight. Not only did Miss Diaz shoot Christopher Jones in the back, she left him to rot, Your Honor. She left him alone in that house for the better part of a month. And there's evidence that she returned at least once, but likely more. She took his phone, his wallet, his watch, his dog, and his car. She used his car, she drove it around, she spent his money, she racked up his calls, she tried to collect rent from one of his friends, she tried to sell his equipment, and in that event, she got the murder weapon stolen. She not only tried to convince his family and friends that he was still alive through her texting them on his cell phone, she also tried to convince the police he was still alive. She impacted his entire family, his mother, his sister, and his aunt, and the children that he had only recently connected with. And so 25 to us is the only thing that even come close to getting any sort of justice, Your Honor.
All right, defense.
Hi, Judge. Excuse me, on behalf of Ms. Diaz, we believe the PSI does discuss quite a few things that I would ask the court to consider. First, regarding the PSI, it talks about her children, and it says she has 4. She actually has 6, just so the court knows. Factually, there are some inaccuracies in the PSI. She has 6 children rather than 4. It does discuss also some things that happened to Ms. Diaz as she grew up and some of the difficult things she faced as a young person. Now, addressing what happened on this day, and the state talks about the fact that the 25 takes into account all the factors that led up to what happened on this day, and perhaps it takes into account some of it, but Ms. Diaz, in her description of what happened that day, you know, she comes clean and she tells the court exactly what happens that day, and she's correct and she's truthful with the court in the PSI. And one of the things I think the court, you know, the state wants you to believe that she just left in there and did nothing regarding the police, but in fact, she tells the court through the PSI that she thought the police had been notified through these people, because she goes immediately and tells somebody what happened. And she tells through the PSI, she says, I thought the police had been notified. And if you read the stipulations, you'll see that in fact, the police were notified. The police were called and told, and they did nothing about it. So while Mary did not call the police, she told people what happened, and those people called the police and told the police. And then for whatever reason, the police didn't believe anything about it. And so when I think it was Vanessa and her roommate or her wife, or whoever it was, when they called the police, for whatever reason, nothing happened. Now, the problem that Mary then ran into is as time passed, you know, it just kind of, you know, it became more and more difficult, and it's kind of snowballed on Mary. And certainly she should have come forward, and she didn't. And she realizes, as she stands here today before the court, she realizes she certainly should have come clean. But as time passed, it became more and more difficult, and she made bad decision after bad decision after bad decision, which led her to make the one decision that, you know, that perhaps was her one good decision, that was to accept responsibility and come before this honorable court today and say, Judge, you know, I'm here. I accept responsibility. You can see in I don't think you've seen a PSI that is as accepting of responsibility as this one is. She tells you exactly what happened. She tells you why it happened. She tells you what was going on between the two of them and everything. And the good thing, if there is any good thing from Mary's version, is it's completely supported by the stipulated evidence. All the trouble that she says they were going through together is supported by the stipulated evidence. The fact that she tried to do something right after it happened and the first aid she tried to administer is supported by the stipulated evidence. So as she stands before you, she is accepting responsibility. She understands the court has to make this decision. She wants the court to know that she understands she's hurt many people. She's made a community feel unsafe. She's caused so much emotional stress to all the people that know about the case. She's done things. She's hurt his family. She's hurt her family. She's hurt everyone touched by this. But she can't change that. She's by accepting responsibility, she's hoping people will see that she's doing everything she can to make it right, even though it's years too late. And then when we talk about years, in this case, we're talking about a cap of 25 years. And the court, has the ability to consider, obviously a cap of 25 means 5 to 25. And we're certainly not thinking by any stretch the court should consider anything between 5 and 25. The court shouldn't. This is a murder case. This is the taking of someone's life. But we're asking the court to perhaps consider something between 20 and 25 years. And I would ask that the court read the stipulated evidence, how it compares to her statement of the facts. I would also ask the court to consider the fact that she spent 1 year in jail and then 3 years on full house arrest. She didn't ask to go work. She
And
didn't ask.
counsel, what does she mean if you turn to page 11? of the
Yes, I was
PSI
gonna
report?
get to that part.
All right, if you can
You're
tell
talking
me
about the
what she
fair
means.
part?
Yes.
Yeah. So when she was asked about that, I asked her about that. I said, Mary, this sounds terrible. And she says, Charles, what I was trying to say was, when this happened, he had been, our situation, his and hers, was a volatile, abusive situation, and I had to make a decision on what to do, how to react. And I reacted in a way that turns out I had to make a decision that at the end wasn't fair to me. And in other words, she doesn't mean that this isn't fair. She means the result, she made a decision that in the end, the result wasn't fair to her, and that she was placed in a situation where she had to make a decision that it wasn't fair to make her make that decision. In other words, he placed her in the untenable situation where you've got to decide to make this decision. And it's not fair to put a person in a situation where you've got to choose either I'm going to do something terrible to you, or you have to do something terrible to me to keep that from happening to you. And that's not a fair decision to put another person in. And that's what she meant. She certainly does not mean that it's not fair that she's before this honorable court. So, and because I asked her about that, I've cringed just like I'm sure you did when you read that. But that she's not inferring or not telling this honorable court that it's not fair that she's here. It's certainly fair. She's here. And if it wasn't fair, we wouldn't be here. We'd be in trouble. Certainly, Mr. Coach and myself, if we didn't think it was fair, we wouldn't have pled. We wouldn't be here. She understands, she accepts. What she meant was it's not fair to put in a person in a position to have to make that choice. Hey, am I gonna have to hurt you? Are you gonna hurt me? And that's not fair to make a human make that decision. That's what she was trying to say on that day, not to you, but to Chris. And so that it was just an unfair position to put another person in. Thank you. So anyway, back to what I was saying is just when you make the decision, we're asking you to consider perhaps, even if it's 22 or 23 years, considering how she came clean in the PSI, and it's shown that in the stipulated evidence. She spent 1 year in the county jail. She spent 3 years on full house arrest. We believe that those factors all combined would justify a sentence of 22 to 23 years, and we ask the court to do that. Thank you.
All right, state.
Just briefly, Your Honor, as you always say, I feel the truth is always somewhere in between. We obviously don't have Mr. Jones' side of the story, and we now have Ms. Diaz's 4 years later. I believe it would probably be somewhere in between, Your Honor. And at the end of the day, it doesn't take away all that she tried to do to hide the truth. She had multiple occasions to tell the detectives the truth. She spent hours being interviewed and she still denied the truth. She also had contact with the police at least once, I think maybe twice, between when he was killed and when the body was discovered. And at no time did she say anything. She knew he hadn't been discovered and the police hadn't gone, because she went to that house, which she talks about, the fact that she went back to the house and his body was still there and she took the dog. So, Your Honor, 25 is the only real option here.
Okay, and I remember, you know, the steps, and I always reread steps. And part of the stipulations, it says that there were text messages sent that appear to be text messages to make it seem as though the complainant was still alive.
Yes, Your Honor.
Did I read that correctly?
Yes, Your Honor. To multiple friends and family.
All right. Does anybody want to address that part of the stipulations?
No,
Okay.
like I said, at some point it snowballed and she got caught up in that.
All right. Anything else from either side?
No, Your Honor, just a reminder that we do have the family for victim impact on Zoom.
All right. Ms. Diaz, I want you to know when the state makes an offer a cap of 25, always consider the full range, because when people offer a cap of something, so I consider 5 to 25. I don't automatically say, oh, I'm giving this person 25 or 24. I consider the entire range of punishment, okay? And I understand what the defense is asking for. I understand what the state is asking for, and I appreciate both people being reasonable in what they are asking for. All right, as previously stated, the court is finding you guilty. The court will give you credit for any time served. The court will sentence you to 25 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. And counsel, I see that there were other mentions of maybe potential toxic relationship, abuse, that type of things. I'll request for you the mental health unit or the therapeutic unit, but you'll have to request it as well, because I don't have any jurisdiction to force them to put you in specific programs, but that may be of help to you. Okay. And your defense counsel will explain more to you about how you could potentially maybe get in those programs. Is there?
Would the court consider granting her credit for the time she was on the monitor?
No. All right, and so we are off the record. My understanding, you have victim impact.
Yes, Your Honor.
Do you know I have a Husi SL112C
No,
and a Teresa?
Teresa for sure. Yeah, Teresa's the,
I think other family that you have walked in just to be part of it,
Okay.
but I'm not.
but Teresa's the,
All right. All right, if you could please unmute.
But you'll have to request it as well, because I don't have any jurisdiction.
All right, are you Miss Felix?
Yes, I am.
All right, and are you is she's the person who's going to give impact?
yes, Your Honor.
All right, Miss Diaz. Victim impact is where family members may talk to you and tell you about how this has impacted their life. Always require that everybody treats everybody with respect, okay?
Yeah.
All right, Miss Felix, you may begin.
Good morning. First of all, Honorable Judge Boyd, we, the surviving family of Christopher Lee Jones, would like to express our gratitude for the opportunity to give a small measure about how our family has been impacted. I was told we'd only have a few brief moments, and I've narrowed it down to 7-8 minutes. If that is at all possible.
Yes.
I would like to start with the statement from his mother, Leela Peterson. I'm sorry, I'm pretty nervous, obviously. Chris was my firstborn and only son. My hope was that his life would be blessed and anointed by God. That's why I named him Christopher, which is Greek, and Greek means bearer, carrier of Christ, anointed, and that he would always be protected by God. When he was growing up, my family and I tried to provide love and support to him in all he tried to do. Music was always his love and gift. As he ventured on his own, I pray that his name will be a self-fulfilling prophecy for his life. His music was beginning to show how special he was. He was completing his first CD, his tribute to God. Throughout the years he was away from home, we would always keep in touch, and he would tell me about his trials and blessings that led him to writing the songs on his CD. He thought he would finally be able to bless others with his songs. Then evil crept into his life in the disguise of a trusted friend and heartlessly ended his life. All the good memories have, all the good memories have been replaced by sorrow, despair, and disbelief that this could happen. I will never again receive a call from him to let me know he's okay and share with me what has been going on in his life. The cruelest cut of all is the reality that he is gone forever from those of us who loved him, and evil still remains. Next, I would like to share with Mary. Mary, I know you know what Chris is going through with his children, how much he missed them. It had been, about 15 years, I believe, since last time he had seen them. I want to share with you what his daughter, his second daughter, Samira, shared. The day I got the call that my dad had died, my whole world shattered. I felt as if time did not exist. Everything was happening all at once, and I felt as if my life was crashing down on itself, leaving nothing but my broken heart. I remember what happened after we got the phone call. I ran to the washroom and began crying. I kept washing my face because I couldn't believe that my dad had died. It felt like a nightmare, but it was one I could not wake up from and would have to live through for the rest of my life. I stayed in my bed for weeks, heartbroken and motionless. All I could do was replay memories of my dad in my head and look at pictures in our texts because that was all I had left of him. All I could think about is how it could possibly be true. My dad is dead. I kept telling myself and praying to God that he was somewhere on vacation and just forgotten his phone, or he'd just been super tired and was resting. And that was the reason why he wasn't answering his phone. I couldn't believe it. How could this happen? Everything was going so well. It was like every other day I was just talking to him about movies. The last thing my dad said to me was about a movie that he recommended me to watch to help me with my social studies project. Even before we got in the news that my dad had died, I was already in grief. I just knew that he was gone, but a small part of me wanted to hold on to the illusions that I had made in my head. I remember I was in math class and constantly kept checking my phone to see if he had answered the message I had texted him, but still there was no answer. That was when I had my first anxiety panic attack. I got up and left class and went to the library where I began to cry. A friend of mine came in to me and asked me why I was crying, and I told her something is wrong with my dad. I couldn't muster up the courage to say I know that he's gone. She told me he's okay and that he's probably sleeping, but I knew my dad. He texted me right back no matter what. It could be early in the morning and he still replied to my text immediately as if he wasn't sleeping and was waiting for me to text him back. It was almost as if I was waiting for a ticking time bomb to go off and there was nothing I could do about it. Our family started to post on his Facebook page to ask where he was and for him to give us a call, but there was no answer. We had then asked my aunt to call the police to do a wellness check, and then we had to wait. I remember coming home after school, and my sister and I knew something was wrong. There was an eerie feeling. Once we got into the house, my maternal grandmother was on the phone with my mom. And though she wasn't on speaker, we could hear her crying through the phone. I've never seen my mom cry like that before, and it pierced through my heart. My grandma put my mom on speaker, and that's when we got the news. It felt as if my heart had cracked and my stomach had dropped. All I could do was go and run into the washroom to cry. The days after my dad had passed away were extremely painful. I would go through our texts and look through his photos on my phone, crying and wishing we had time, wishing that I could just say goodbye and tell him everything I wanted him to know. Like how much I miss him every day, how much I want to hug him, how much I want to see him again, how much I love him, how I am proud of him after all his adversities, that he's gone through, and how he inspires me to do better and not give up. I wish every day that I could have the chance, a moment, even 5 minutes with my dad, but that will never happen. When I went back to school after weeks upon weeks and still was grieving, my friends were giving their condolences, but it felt as if all their words went into my ears like an empty black hole and disappeared. I was in disbelief, and all I could think about is, how is this even possible? How can I be in a world where my dad isn't here? It didn't make any sense to me. I couldn't believe that the only thing that I had left of my dad were pictures and memories. He was just here. He was just here. So how could he be gone forever? I have a hard time accepting my dad died. I know that eventually everyone passed away, but I thought that my dad would at least have more time before he passed away. I would be there by his side, being there for him and help him through his final steps. I thought that he would at least be given one more moment before there would be no more moments at all. In fact, I still cannot believe it. I catch myself reading through our text and calling him, crying, hoping he'll pick up, knowing that will never happen. Every time I try to talk about my dad, all I can do is cry. I have problems sleeping because of panic attacks and anxiety. I fear losing my mom and my family. I can't handle it. When my dad died, all I could think about is why? He didn't deserve this. He didn't deserve what happened to him. Nobody does. And nobody's family deserves to go through the pain my family has gone through. This last year, I came to the realization that I'll never see my dad again, speak to him, hug him, and tell him how much I love him, or even spend time with him, because that was all taken away. When my dad died, I cried so much to the point that I couldn't physically cry anymore, and crying became painful. My eyes would burn from the tears, and my throat was so sore till I couldn't speak, and even to drink water was painful. I couldn't. I was in too much pain. I was heartbroken. My dad's death didn't just change my life; it shattered and destroyed it. I became so distressed that my pituitary gland became extremely swollen, and I had to get MRIs. I began to have headaches constantly, and all I could take was medication after medication. I would be sick all the time and could not sleep because of how bad my anxiety and panic attacks had gotten. And I was only 16 at that time. All of this is caused by the stress I endured from my father's death. It didn't just shatter my heart and break me on the outside, it broke me on the inside as well. Before my dad passed away, I was getting straight A's in school, but when he died, I couldn't do it anymore. I felt as if studying was a waste of my time. I realized how short time is. I couldn't waste my time studying if I could spend it with my family, because how would I know if this was the last time with them? I found myself trying to compensate for how I felt about the waste of time I spent studying, when I could have been talking to my dad, when I could have been replying to him, talking to him, instead of telling him, "Dad, can I talk to you later? I'm studying right now." But I'll talk to you later. I love you. One of the worst words, later, because later never came. Later didn't exist for us. I graduated in the class of 2022, and I remember when I was watching my classmates walk the stage, all I could think about is how my dad was so excited to see me and my siblings graduate, but that was taken away from him. And the day that was supposed to be my happiest became my saddest. All I could do was to try not to cry as I heard dads cheer for their daughters as they walked across the stage, on to the next chapter of their lives, knowing that my dad would never be able to do that. Excuse me. For many people, when they lose their parents, it's by old age, and they know they're about to lose them. They are prepared. Family members can say their final goodbye and have closure before they lose their parents, but I was never awarded that. The last thing my dad ever said to me was, "Hey, Samira, what's up, Angel? Did you watch that movie yet?" And I never got to reply. I never got a chance to say I love you. I never got a chance to say goodbye to my dad, because that was taken away from me and my siblings, my family, and the people I love. Dad, I love you so, so, so much. Words can't even express how much I love you. I'm so, so proud of you. I couldn't have asked for a better dad, because even if I did, I would just get you. I wish we had more time, because a few words can't express how I feel. I'm so grateful for you. You made me a better person. You made me realize so many things I didn't know about myself. You inspire me. You are me and I am you. You are my life, my moon, my sun and my star. Not just my world, but my entire galaxy and universe. You are my existence. Samira Jones. Oh.
Okay, Teresa.
This is hard. You know, we lost a big piece of our family. Everyone has things in their life that they wish they could change, and things that sometimes happen that they wish didn't happen. But to cover up and do the things that you did, Mary, I mean, you text me from Chris's phone telling me how Chris decided he was going to leave our whole family behind. He was moving to Texas and all this, and just rambling on and on about as if, and then when I tried to call his phone, I'm saying, Chris, why is Mary text me from your phone? Of course, I didn't know what happened. That was so cruel, and just leave him there. Do you realize that when we got his body back here, that was during the pandemic. If he had been discovered a day or two later, we wouldn't have been able to even get him back here because everything shut down almost the day or two after we finally got his body back here. I don't know what else to say. I hope God has mercy on your soul and that you understand what you have caused, whether intentional or not, I don't know. This is cruel. That's all I can say. Thank you, Judge Boyd, for letting me take the time to express our feelings.
All right, thank you. I'm sorry for your loss.
Thank you so
I'm sorry.
much.
No, I'm not.
Oh, that's right.
Yeah,
Sorry.
thank you. I'm sorry for your loss.
Thank you.
All right, thank you. RC Curtis, your client is not on the Zoom. Is he, Kusi?
He was.
All right, Mr. Curtis?
We have an interpreter here and it. Pull it back. Okay, never mind, hold on.
Oh, there he is. Excuse me, Judge.
All right, where are we on this trial? This should be going to trial. Where are we?
Well, it's my understanding that the court of has issued mandate like within the last week, so. Go ahead, I'll let you.
It was actually on the 13th and I
On
did
the
email
13th,
you.
yeah.
Everyone, please whisper.
Mandate's been issued by the 13th Court of Appeals. I did email you a copy of it today. And so I understand it's mandate to the trial court.
Yes, I haven't received that yet, so.
Don't know if it's.
Do you have a copy with you?
I can forward the court an email or I can print it off and have it presented to the court.
All right, you want to print it off so I can see what
Yes,
they are
ma'am.
saying?
Should be 2 cases. You want us to step back?
Oh, no. It should take them 2 minutes to print it, right?
Okay, thank you.
How you open just.
Okay. Does he need to be in here?
It needs to be in here.
All right, Mr. Bach, if you just step to the side, I'm still going to keep you on deck though, okay?
Yes, Judge, thank you.
Johnny Trevino.
He's walking up.
All right, are you representing him?
Yes, he just hired me yesterday, Your Honor.
All right, Ms. Ferguson,
Yes, ma'am.
on Johnny Trevino, counsel, did you confer with the state?
I reviewed the discovery with my client. I haven't conferred with them because I haven't had a chance to review all the discovery. There's really nothing to confer about.
Ms. Ferguson, I need a reset date on Johnny Trevino for 30 days.
Yes, ma'am. I can do. Let me go back to that. I can do the 26th.
All right, state on Johnny Trevino, you need to be prepared with an acknowledgement of discovery and also an offer on August 26th, you say?
Yes, ma'am.
All right, once you sign the reset form, you're excused.
Thank you, Your Honor. You have a good day.
You too.
Attorney Albert Acevedo. Yes. Alberto.
All right, Ms. Ferguson, what page is he on?
He's on page 6. Judge.
Okay.
He's in a Zoom.
Big difference.
I need the email address.
John Paul Pena. Is the attorney here for John Paul Pena? No, where's your attorney? Who is the attorney for John Paul Pena?
Sorry, Judge, I was talking.
Thank you. And did you introduce yourself to the court reporter?
Kyle Simpson.
All right, today is the plea deadline date.
We're gonna set up a trial, Judge.
I'm sorry.
We're gonna ask for a trial setting,
All right, how long will this be for trial?
like 3 days, 2 days.
All right, Ms. Ferguson, Criminal Trial Division, I need a jury trial date for 2 days. It's John Paul Pena.
Hey, 1 second, Judge.
Sorry, I didn't hear you.
That's okay.
You said it's a criminal trial division?
Yes, it's a 2-day trial. It's a theft case.
I can put it for, I'll do October 1st.
All right, your jury trial date is October 1st. You need to sign the reset form. Once you sign the reset form, you're excused. And state, if I could get an acknowledgement of discovery on John Paul Pena, please. It's 2024 CR 6530.
Yes, sir.
Thank you.
Thank you, Judge.
Dennis Johnson.
DJ. Morning, Judge.
All right, Mr. Johnson, come forward.
Yes. Cornelius Scott.
All right, today is your plea deadline date.
Judge, if I may,
Yes.
there was an issue with discovery. I brought it to the court's attention, kind of off docket.
All right, what's the issue
I
with
have-
discovery?
Well, for some reason, Odyssey wouldn't let me download. Angel was on it, trying to get it. I brought a hard drive to the state today.
Mr. Peña?
All right, Ms. Ferguson, on Dennis Johnson, I need a reset date to the end of August. This will be your final plea deadline date.
Thank you, Judge.
I can do August 27th, Judge.
All right, it'll be August 27th. Once you sign the reset form, you're excused. Thank you for dressing appropriate for court.
Oh, thank you, Judge. Oh, I appreciate it.
That's a given with you, Mr. Cox.
Have to see that right here.
Nora, what page is he on?
I am looking for him right now.
Oh, it's on page 5.
Thank you.
You're welcome.
We're ready.
Can you approach the discovery?
And my client in the one that's in the Dunbar. Yes. We're ready to announce on that one. That's the one that's in the on Zoom.
All right, is that going to be a trial?
No, Your Honor, we're gonna, there was an offer made. My client now remembers it. And we need a date for the plea. He's out of town unless we can do the plea by Zoom.
All right, just a moment. Mr. Dunbar. I'll get him to come back by closing all rooms. All right, so the people on RC Curtis, how long do y'all expect trial?
Your Honor, my witness list constitutes 17 witnesses. If we recall, when mistrial was, we go on
How
2
long do
days.
y'all expect the trial?
State's
2
case.
All right, so Ms. Ferguson,
Yes, ma'am.
they need a trial date on RC Curtis for 2 weeks. I want this case tried. What's the earliest we can get them in?
That's,
And it doesn't have to be the beginning of the month because it's not involving either of the prosecutors that are currently in this court. And I don't want this for trial for next year. I want it done this year.
Can we step aside and talk to her and then come back to you?
Sure,
Okay.
but,
It's
Ms.
gonna-
Ferguson,
Yeah.
not next year.
No, I know
It's
that.
gonna
I know
be
that. I'm just trying
incredibly
to.
difficult.
Oh, we'll make it happen.
I've got to get Ms. McGinnis on the phone also and try to find her schedule.
Oh, it'll be fine. It'll work out.
That's,
All right, Mr. Dunbar? Unmute, please.
Yes, ma'am.
All right, you're currently out of state. Why are your lights off? Power outage?
I think it's in Houston.
Yeah.
All right, thank you. Just have a seat. A stationary place, please. All right, you're in Houston?
Yes, ma'am.
All right, so Mr. Cox, we're gonna recall this, and your client will need to be present in court if he is not able to fill out the paperwork for the plea by Zoom. Miss, you need to have a seat in the back. So do you think you'll be able to do paperwork by Zoom?
I can do the paperwork by Zoom if it comes to me and you've never seen.
All right, state. Dunbar, his paperwork is gonna be done by Zoom, but I know we're extremely busy today, so it's not gonna happen today. So, Mr. Cox, we can do it next week by Zoom?
Correct, about Tuesday.
All right, Ms. Ferguson, on Dunbar, it's gonna be for a plea by Zoom. Ms. Ferguson needs your client's email address and so do the state.
Yes, sir, I'll get it. Hiroshima, what?
You come with so much history. I love that.
Nagasaki. I didn't know that. That's when they got. Oh, wow. So I'll get that information.
Yes, you'll need to give Ms. Ferguson his email. And if you could give that to her before, yes.
Okay, thank you.
All right, the latest, let me help you all out. The latest this is going to be for trial is November. That's the latest.
We're looking at the beginning, we're hoping we can get beginning of December. There's no way we can do it by November. It just is calendar.
Why not?
We can't. Oh, there's just too many other things happening.
I would point out, Your Honor, and I have filed a notice letter with the district clerk. I'm out of the country from
When?
the 8th of October through the end of the month.
And there's nobody else to try it?
Can you take us off of, or can you mute us off of the World Wide Web?
for jury selection. Mr. Curtis, you need to be in court on December 2nd, dressed for trial. We're going to have jury selection on that day.
Can we get a motion setting like a month before that? Everybody?
I'll just speak with Ms.
I will.
Ferguson
Okay, thank you.
and we'll set that
Okay.
at that time. And I'm assuming everybody has copies of the transcripts. You should.
I do.
All right. All right, December 2nd. Thank you, guys.
Yeah, may I be excused? Yeah.
Yes, you may.
Thank you, Judge.
Thank you.
I'll get you all the motion setting. I'm not even sure what I'm talking
And Mr. Bond,
Yes,
you'll let Mr. Curtis know?
I will.
All right, thank you.
Yes. Okay, yeah. I don't know.
Number, what page is RC Curtis on?
On the very, very last page, Judge.
Thank you. Sorry. Who is here on Jacob Villalobos? Introduce yourself to the court reporter, please. Probation, there's no application. Court is calling 2024 CR 0070013, State of Texas versus Jacob Villalobos. Could I have parties announced for the record for the state? Defense,
Ray Lopez for the defense.
and are you Mr. Villalobos?
Yes, Your Honor.
Counsel, you received all of the discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Off the record for a moment. Excuse me, defense counsel, if you want to speak to your client, don't speak behind the court reporter. Ask the deputy to have them move to the end. We're back on the record. Mr. Villalobos, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Waiving the habitual offender enhancement allegation.
Any objection?
No, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, Your Honor.
You're charged with the offense of attempting to take a weapon from a police officer. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Villalobos, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 18 months in the state jail facility, and there are no applications. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, Your Honor.
Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Contained in Exhibit 1 and attached.
Any
No
objection?
No objection, Your Honor.
State, you may be excused.
Thank you, Your Honor.
Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
All right. Can someone tell me, because I'm reading in the stips that he was called for alleged family violence. Is there a family violence case out there somewhere on him?
I don't believe so, Judge.
Do you have a family violence case? All right. Who is Tiffany Lee Carlisle to you?
My ex.
All right. Do you all have any children together? All right. Court is going to find you guilty, sentence you to 18 months in the state jail facility, give you credit for any time served. There's to be no contact with Tiffany, Tiffany, Lee, Lee, Carlisle, Carlile, and no contact with Margie, Margi, Lou Munoz. Is there anything else with regards to sentencing?
No, you're nothing from the defense, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yeah.
All right, we can go off the record. Here's the thing, trying to take weapons from officers, you could have ended up being on the news and your mom or dad would have been crying saying, the police killed my baby, what's going on? You're not allowed to do that. If you would have just came outside and talked to them, you probably wouldn't even be here. You're labeled as a habitual. You know what that means? On certain cases, your minimum will be 25 years in prison. If you want to spend the rest of your life in prison, I'm sure Texas will accommodate you. Do you understand?
Yes, ma'am.
And if you want to get more face tattoos, that may be limiting your job opportunities, but you're more than welcome to do so. It's a free country.
I'm fine with what I have now.
All right, good luck to you, okay?
Thank you, Judge.
You're welcome. Seth McDonald. All right, where's Mr. McDonald?
Inmate in custody.
Come down, please, Mr. McDonald.
This 701.
Family violence, McDonald.
Middle.
Good morning. Hello.
Morning, Judge.
Morning. So this is, are we doing a plea? What are we doing here?
At the prior setting, there was an offer made and we learned that there was a sexual assault case that had popped up.
Mhm.
At this moment, it's our understanding that we're only looking realistically at this sex violation case. The offer is standalone. It won't touch any new case. I discussed this with Seth, with Mr. McDonald. He's asking for some time. I know that Monica Guerrero is in federal court today. She's not able to talk to him today.
Okay.
Sometime in August, if we can come back on the 27th, 20th, 13th, just some date, Tuesday in August.
All right, let me ask this. what is up with this case that's supposedly out in the universe?
It's a sealed at-large case, Your Honor, so we
What-
don't really know anything about it ourselves.
All right, so when is that gonna be taken care of?
I can't tell you, Judge, I'm not sure.
We had asked to see if there's something we could do to prevent that being filed, and it's too premature for that to happen.
All right, Ms. Ferguson, set this on August 13th.
Yes.
All right, we're gonna come back on August 13th. All right, thank you.
And Your Honor, regarding, not with Seth's case, but there's another off docket, there's a bond issue case, somebody from the jury box, Davy Durkin.
All right, just give me a moment.
I checked if I could approach.
All right, just give me one moment. All right, Ms. Ferguson, what plate? I found him.
Let's, in order to sign this.
All right, and state on McDonald, that's gonna be the final date for discovery. Eric Kelly.
Alberta Campion.
All right, what is happening with this case?
Your Honor, we've been in a holding pattern.
Inmates,
waiting-
no talking in the box.
Waiting for an
you.
indictment on an aggravated offense. We checked a few minutes ago, it still is unindicted.
All right, what is the alleged aggravated case?
I don't represent him on it. I think it's an aggravated robbery.
Yes, it is. And I'm assuming this is criminal trial division?
Yes.
All right, so we're gonna get out of the holding pattern. This is gonna be the last reset that I'm giving everybody for discovery. This is it. After that, state the date I'm gonna give you. I'll need an offer tendered. And then we're gonna move forward to trial if that's where this leads.
Yes, Your Honor.
Ms. Ferguson,
Yes, ma'am.
I need a 1-month reset on Mr. Kelly.
August 27th.
All right, we're gonna be back on August 27th. State will make you an offer and discovery on that case that is unindicted. He'll still need discovery in order to handle these cases. All right, thank you for addressing appropriate court. Once you sign the reset form, you're excused.
Thank you, Your Honor.
Yeah.
Yes.
Thank you.
Norma, I see him on page 4, but he's on more than one page, correct?
Yes, ma'am.
Ah, got it. Who is here on Stephen Carmona? Thank you for your patience, counsel. All right, and where's Mr. Carmona?
He's walking up, you know.
Okay. Hello.
Morning.
I need. Mr. Campion, I need to know.
All right, who is the prosecutor on Stephen Carmona? Actually, it's family violence.
If I understand correctly, yes.
All right, if you all will come up because this is in regards to GPS, he wants to change it.
We haven't conferred it all today, Your Honor, so we're happy to confer with counsel and then.
All right, Mr. Cisneros, if you'll talk to them about the GPS and time when you're ready, just come back up.
Yes, ma'am.
All right, thank you. Darius Murphy. Just have a seat.
Yes, Your Honor.
Oh, you're the attorney? Come on down, Mr. Murphy. All right, this is to set a bond and he's scheduled for PTD.
Yes, Judge. We have updates as to both. We did execute the PTD agreements and we did send that into the DA's office today.
Okay.
So that part is covered, Judge. And then I did confer with the DA's office. They're in agreement with the potential bond being set at 1,000. Being so low because restitution is owed on the PTD case, Judge. So we want him to try to make those payments as soon as possible for that.
All right, court is calling 2023 CR 11123, State of Texas versus Darius Murphy. Can I have parties announced for the record for the state?
Andrew Harris, Edelman.
Defense?
Renee Munoz.
And are you Mr. Murphy?
Yes, ma'am.
All right, you're here. Your attorney has requested a bond be set. Defense, is my understanding you have an agreement with the bond?
Yes, Your Honor.
And what is the proposed agreement?
We're asking that the bond be set at $1,000, Your Honor. He has virtually no criminal history for this offense, and he has been approved for pretrial diversion, Judge.
All right, state, are you in agreement with 1,000?
Apparently we are, you know.
According to
Okay.
Daniel and Gary, yes.
All right, and since he is being approved for PTD, and that's been an agreement, there are certain connotations that come with that, namely that he doesn't have a violent criminal history. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Darius Murphy.
All right, would you have a place to live if you were released?
Yes, ma'am.
Who would you be living with?
I have an apartment out here.
All right. Do you have any family members here?
No, they live in Houston.
Okay. And do you have employment?
Yes, ma'am.
All right, what do you do?
I'm a salesman.
Okay. And has there been any drug history?
Any what?
Drug history with you?
No, ma'am.
All right. Any alcohol, marijuana, anything of that nature?
Occasionally,
All right, you're not allowed to smoke marijuana while you're on bond, you understand?
yes, ma'am.
And you're not allowed to smoke marijuana since you're trying to obtain pretrial diversion, do you understand?
Yes, ma'am.
All right, and the next question is, any mental health conditions
No, ma'am.
ever been diagnosed?
No, ma'am.
All right, the court is going to set your bond at $1,000. You are already set to be back in court on August 8th. Ms. Ferguson, if you'll make sure he has a reset form for August 8th, please.
Yes, ma'am.
Is there anything else?
Nothing further, Your Honor. We appreciate it.
All right, thank you.
Thank you. Once at 1,000.
Yes, thank you.
You said August 8th, Judge. correct?
Yes. Which page is he on?
He's on page 12.
All right, thank you. And it's PTD, Norma.
Yes, ma'am.
Going.
Tyler Ashbaugh. And attorneys, please remember to introduce yourself to the court reporter. Hello, Nathan. Long time no see.
I know, it's been a while, Judge.
How are things going with family life?
Good.
Oh, that's good.
The kid is sleeping a lot better.
All right.
That always helps.
Yeah. All right, last time we were here, there's something about inspecting and downloading data from a vehicle. Where are we on that?
Yes, Judge. So I'm going to be requesting one final discovery compliance date. And just to give you a little bit of background behind that, I have inspected the physical evidence. We had an appointment with the detective. We went over all that. We have not been able to do the extraction on the vehicle. We were set one time. The detective at the last minute had a subpoena for a murder, so he was unable to make it. And then we were rescheduled. However, in order to be able to do the extraction, the vehicle at least has to be not completely on, but powered on to the battery, or else
Okay.
we're unable to extract it. I assumed that the state had a key in their possession based on some other evidence. When the detective was getting a statement from the defendant, it appeared that the detective had in his possession the key to the Nissan Rogue that's the subject of this case, Judge.
Take care of it.
And so, however, they stated they did not have the key. When I went to go inspect the evidence, I did not see the key. However, the defendant's father, it appears, recently found out that he has a spare set to that. So I would still like another discovery compliance date so that we can set up a date just to do this extraction, Judge. And
How long are you asking for?
probably till the end of August at least, Judge, because our expert is not going to be available until August 9th. He's out of town. Also, Judge, just the index alone on this
All right,
discovery.
Ms. Ferguson, set this for discovery, August 29th. Is that enough time?
I think that should be plenty of time, Judge, and let me just confirm that I'm on that date. Yes.
All right, Ms. Ferguson, what page is he on?
He's on page 3, Judge.
All right, you're gonna come back on August 29th. This will be the last date for discovery, and state if you'll be prepared with an acknowledgement of discovery on that date.
Yes, sure.
Thank you, Judge.
You're welcome. And I'm sorry, Ms. Ferguson, what page? Thank you. And Mr. Ashford, thank you for dressing appropriately for court. You may be excused. And Norma, that's final discovery. Daryl Payne. All right. And where's his brother?
He's standing right here, Mr. Donovan, Judge.
All right, if you come forward. All right, if you can just remain there, Mr. Payne, if it's hard for you.
Judge. Yeah, he's already been sent.
Hello, I remember you, and thank you for being an advocate for your brother. People who have mental health issues and people who have medical issues, they really need that. So, I want to coordinate so that he can be picked up from the jail and not just be sitting there. And they will release them sometime at midnight. So this is what's going on with him. I'm trying to get everything in place for him that he needs. One of the things that he needs, of course, is there's some mental health that's going on. There may be some drug issues that are going on. So he's being referred to felony drug court. Felony drug court is going to see him this week. Attorney Munoz will coordinate with you so that felony drug court, the people there will have your contact information so that they can coordinate releases. I don't want him to end up leaving the jail and being homeless, because then we're going to be right back here. So that's why I have felony drug court sort of in place. So they're going to speak with him this week. Mr. Munoz will coordinate with them. And when they're ready for him to be released, they're going to let Mr. Munoz know, and then he'll be released, and Mr. Munoz can coordinate with you so he won't be just at the jail and then maybe picking up a new case, which we don't want to see happen. So wanted you to be sure what was going on. All right. So is there anything else that would be needed, counsel?
I don't believe so. I think the court did an amazing job in helping coordinate this all, and we appreciate the court's time. We did notify that he can live with the brother and help with the Center for Public Services appointments judge. He did provide information that he can pick up his brother during the week after 4 p.m. because he has work obligations before then, and he did provide me with his number. I don't know if there's a way I can give this to the court so that there's a note made that
Well, I tell you what, the way to handle that sometimes when they have, like when we have people being picked up by lifetime recovery, if you, because we don't have B pages or D pages that we can print off anymore, if you will bring me a motion for the time, again, coordinate with drug court. And if you'll let drug court know that he will have a place to stay, because drug court will put their own rules in place, and they may be assuming that he doesn't have a place to stay or somebody to watch out for him. If you will let them know, because who knows, they may have a better placement for him. And then if you will prepare a motion, if they don't have a placement for him,
okay.
what's the best time for him to pick his brother up?
Okay. And then just in that motion, just state the specifics after 4 p.m. during the weekday, and he can be reached at a number.
And he can be released too, and put his name in there.
Yes, Judge.
So they'll know to expect him.
Definitely, Judge. I can do that.
All right, but make sure that you coordinate with felony drug court, so because I don't want him released until they've done the assessment.
Yes, Judge. I reached out to Ms. Zamorano yesterday, so I do have her contact info, so I can readily relay that information.
All right, and all right, thank you.
I mentioned something.
Yes.
I had mentioned to Mr. Munoz how much I appreciated him, but there's just a concern about my brother is very, very respectful to me. However, I lose a little control when he doesn't come home because he loves to be downtown. He believes he's a tourist, and I do too, but if he just comes home, I could assist him with taking his medication, and I'm even willing to take him to his Center for Healthcare service appointments.
All right, so what we're gonna do is I'll put certain orders in place with him so that we can make sure that happens.
Appreciate it.
All right, so Mr. Payne,
Right.
your brother is telling me it's fine for you to go downtown, but you'll need to be home at. Okay, all right, so we're gonna make arrangements for that because I want you to be successful on this probation, okay? All right, okay. All right, so we'll make sure we coordinate things. And in this court, let me just tell you, to be successful, communication is key.
Yes, ma'am.
So you can always contact his probation officer if things are not going well.
Okay.
Mr. Munoz will tell you can always come back to court. And you have anything for me? All right.
All right, Judge, thank you so much. You can be excused.
Yes, you may be excused. All right, thank you. Yes. Okay. Okay, where's Durkin?
It's off docket. He walked in to try to resolve a warrant. His family's here. He's in the jury box.
All right, so what are we doing?
And I conferred with Jason already.
Oh, you know what? They gave me something to sign. Can you grab that back? It was,
Violations.
For the violation was it? Did you pick up and you put a warrant?
There's at least 2 violations.
all right, can you pull something on that for me? So I'll see what's going
I
on.
have a seat.
All right, thank you. Marissa Magana,
Present, Your Honor. Ready? She's in the box.
Anthony's the one.
come down, yes. Who's the prosecutor?
Jason.
All right, and we'll take care of that today.
If I get out without permission. sorry.
No problem. So, State, are you aware of what's going on?
Yes, Judge, I've talked to him more extensively about it. We've sort of come to an agreement to reinstate, and I don't know. He said he's spoken or been on the bonds with that they're willing to get back on the bonds or be on the bonds still. But one of the caveats was full GPS. And I think that might, there were a little hiccup there. If you have, she would have space that you stay in front.
So that is correct, Your Honor.
All right, and so the court is aware, and the information that defense counsel presented to me was there was an abusive relationship and that then there was a mental health breakdown.
Yes, sir.
And
And I've had the documentation to show Jason as well
Showed me
on the
some
dates.
documentation.
all right. So you're asking that the bonds be reinstated and that should be placed on full GPS.
Yes, the only caveat, and Judge, we're just thankful that the court's giving us these moments. And so the only problem with the GPS is right now, she has an aunt and a grandmother in Kyle, Texas. She's been.
They will do GPS there.
That'll be good.
The order just has to be written a specific way.
That's the only issue because she doesn't have a place here,
All right.
not a secure place.
All right. Ms. Ferguson, on this case, recall this for the end of August. All right, we're gonna be back, recall August 27th.
Yes, ma'am.
And counsel, you'll need to, we'll go on the record. Court is calling 2024 CR 5961, 5962, 5963, 5964, 5965, State of Texas versus Marissa Magana. Can I have parties announced for the record?
Jason Garahan for the state, Your Honor.
Anthony Zamora from Marissa Magana.
All right. And are you Maigana?
Yes.
All right, and defense, we had a discussion off the record. Is the court's understanding in this, you're the attorney who's on the bonds?
Yes, ma'am.
And are you asking that these bonds be reinstated?
Yes, ma'am.
All right, and the court did hear off record that there was an issue of an abusive relationship that Ms. Maganana, I'm adding too many syllables, Ms. Magana had to leave the residence for self-protection, that there was then mental health crisis, and that she was placed in a facility to address the mental health issue. And the defense has shown documentation to the state of that hospitalization. Is that correct?
That is correct.
And then the defendant can no longer live where she is due to the abusive relationship. And she does have a place to stay, and that will be in Cal, Texas.
Yes.
All right. And the state is requesting that is in agreement to the bond being reinstated, but asking for full GPS.
Judge, we have no, at this point, we have no objections to anything. I don't know if she's gonna be able to seek employment or what. I guess we can always address the court.
All right, this is what the court will do. Court will follow your agreement, reinstate the bond in each cases at the request of the bondsman, which is defense counsel. The defendant will be placed on partial GPS, and the partial GPS will be for medical appointments only. If there is employment, she'll have to approach at another time to address that. And state, do you have any objection to partial GPS for the medical appointments?
No, Your Honor, the only concern was that I believe that this individual had cut off a previous GPS device, and that's why we asked for the GPS.
All right. And Ms. Magana, the only reason why, well, one of the reasons why I'm reinstating and placing you back on GPS, because normally people who cut off their monitors, we next hear from them at the jail. The only reason why this is being done is because the court is aware and your counsel has presented documentation of the mental health crisis and because of this relationship. You understand?
I understand, Your Honor.
So do not remove the GPS monitor again, okay?
I understand. I
If,
won't.
if there's a crisis, you need to pick up the phone, call your attorney, call someone
I
so they can give
understand.
you guidance.
I understand. I made a report to the police as well for the sexual assault.
All right. All right, Ms. Ferguson, if you can give them a reset date for August 27th. And counsel, you're going to need to prepare that motion for me to sign. They don't have B pages anymore.
Okay, the motion to reinstate? I don't think it was,
Yeah, just put on there, reinstate bond,
okay,
agreed order, reinstate bond. And you'll need to do the partial GPS in there.
okay.
And that the defendant is allowed to reside in Kyle, Texas. All right,
Thank you, Judge.
you're welcome.
Judge, I just wanna
Thank you.
point out, I'm only showing a warrant on one case. That's the case ending in 6-1.
All right, well, I will put it on that.
Thank you.
All right, thank you.
Thank you.
And the 27th date is for discovery?
Yes.
Whenever you're ready, Your Honor.
All right, thank you. All right, and Mr. Cisneros,
Yes.
who is your client?
Carmona?
Carmona, please come forward. Hello, we're back again.
Yes, ma'am.
Johnny, it's turned into a long day.
It has.
All right, so this case is about the GPS. He wants it to be tracking.
State is unopposed, Your Honor.
All right, we're gonna go on the record. Court is calling 2023 CR 8639W, State of Texas versus Stephen Carmona. Can I have parties announced for the record? State.
Zach Dunn for the state.
And Johnny Cisneros for Mr. Carmona.
All right. And are you Mr. Carmona?
I am, yes, Your Honor.
All right, defense has filed a motion requesting tracking only. Any objections, state?
No objection from the state, Your Honor.
All right. And state, do you know, will the complainant be made aware?
Yeah, yes.
All
Yes.
right.
And Your Honor, if I may, I have one more request that came up today, and I should have told them, I'm sorry, I completely forgot.
Mhm.
She's having an opportunity to go to work, go and come nights,
Yes.
to work
Oh,
outside of.
I have
Bear County.
business travel. I'm a call center director, so I need to travel to Waco, Texas and Minneapolis, Minnesota.
Well, you're on tracking only, so. Yes,
So yes.
yes.
Thank you, Your Honor.
I would like to point out, there's a night mag. I attached the docket sheet and the motion. for the
Yes.
night mag on there as well.
Thank you. All right, so that will be for tracking only. All right, and then your case, this case is set for August 26th. Ms. Abrams, his case is already set for August 26th.
Yes, Judge, so for the travel to out of state, travel out of state, I see dates and you are okaying that travel. is that
Yes, I'm okaying travel for business purposes, and you'll need to make sure you provide those dates to probation. If you do not provide those dates to probation, you will not be going. Do you understand?
Yes, ma'am. To my officer?
Yes,
correct? Anyway, immediately upon return.
yes. So you're allowed to travel for work, UA upon return. Do you understand?
Yes, ma'am.
All right, and then with regards to the pending DWI,
Yes, ma'am.
we'll just put that on August 26th as well.
Okay, thank you.
Thank you, Judge.
All right, thank you.
May we be excused, Your Honor?
Once he signs the
Yes, ma'am.
reset form for this, he's excused.
Yes, ma'am.
Thank you.
I'm gonna go over there and take some pictures for you.
All right, thank you.
Okay, well, okay, give me a second.
File on Christopher Lisa, because
Is that a cookie?
All right, is the immigration person here on? All right. Sergio Morris.
Present on that one. Good morning.
All right, where's your client?
He is not here, Your Honor. He is a fugitive. This is one of the older cases that we've been recalled on to give the court an update. And I'm just letting the court know, we've done some background searches on this individual. We in our office do not have any record of him that I can find at all. I did some searching just to kind of see what I could find of him. The only thing that even came close was perhaps an individual that currently lives in California. That sort of matches the full name, but the date of birth seems to be at issue here. So I know he's been missing for quite some time. What I did want to ask the court is if we were to submit a motion to withdraw with a statement of the facts as far as what we've looked into.
I'll consider it.
Okay.
Yes.
Very well.
State
Yes, Your Honor.
on Sergio Morris, this is some case that Odyssey pulled up.
Yes.
So it's extremely old. I don't know, it's from 1990. So I don't know what your plans are with that. Of course, Mr. Morris is not here. So we'll just recall this and I'll recall it for the end of the month
Very
for
well,
you to
thank you.
file your motion.
Very well, thank
Can we
you.
put it on August 27th?
Thank
All
you,
right,
Your
so
Honor.
we're gonna bring it back on August 27th.
Yes, ma'am. Thank you.
Thank you.
Mr. Attorney, can you give me your name?
First name, surgery.
That's not.
Yes.
How many did you invite?
Yes.
If you are in a.
Judge Magana, her warrant is actually on a night map.
All right, if you're pulling out. Alexander Rodriguez. And attorneys, please introduce yourself to the court reporter. I don't know how many times I have to say that.
Yes.
Okay, and I tell everybody, don't whisper over here, just go over there.
She knows me, Judge. She's got me by now.
No.
She said yes.
Alexander Rodriguez, where is he?
In
Come
custody,
down.
Judge. Yes.
All right, on this case, where are we on discovery?
Judge, we do not have any discovery. The Odyssey system tells us there is nothing available. I have discussed that with the state. They are working on it. We have not been able to get a single piece of discovery. This is a first setting.
And my co-counsel, they checked Veripic, and I think there's some issues there, so we're gonna reach out to the intake attorney directly and kind of resolve these issues, because that's a little abnormal.
All right, and could someone please send an email to IT or whoever's over Odyssey that it's not allowing defense attorneys access to discovery?
Sure, well, yeah, we can, the
Well, I
big
think
thing,
I'm sending that message out to defense attorneys. Somebody needs to contact them. And because I'm not the Odyssey IT or tech person.
well, for this,
And
Yes.
we've talked to them, Judge, but we can
All
keep
right,
trying.
so this case,
on this case.
CPS records.
We don't know. We haven't had a chance. Again, not everything, there's kind of a dearth of information, even on the Veripic side for us to look at. So that's why we're gonna go up there and talk to the intake person and say, like, where you indicted this, like, where did you choose to indict this case?
Okay, so let me ask you this. Allegedly, is this involving someone who's living in the home? Do we know?
Not,
Is this a relative?
I haven't read anything, Judge, so. Daughter,
All right, so there are going to be CPS records.
correct. Correct. There are going to be CPS records.
So if you all can already start working on getting CPS records, and we're going to call this back at the end of August to see where we are on discovery.
Sure.
Yes.
All right, Ms. Ferguson, I need a date for the end of August for discovery.
The 26th.
All right, we'll be back on August 26th.
Thank you, Judge.
All right, anything else?
No.
All right, thank
No,
you.
Thank you.
Ms. Ferguson, what page is he on?
Page 1.
Thank you.
Thank you.
All right.
Davy Dirkland.
This is.
All right, who's the prosecutor on Dirkland? Thank you.
Morning, Judge.
Good morning. All right, court is calling night mag number 755032, State of Texas versus Dirkland Davy. Can I have parties announced for the record for the state
Jason Garrett, hey, John.
defense?
The attorney of record is Monica Guerrero. Joseph states in standing in.
Do you have any objection to this attorney standing in?
No.
Are you Dirkland Davy?
Yes, ma'am.
All right, we're here. There's a warrant that was issued because you did not put ignition interlock on a vehicle. Does anyone want to address this?
If I can first say something, Your Honor. Mr. Dirkland had a misdemeanor DWI, County Court 12, that I don't believe that there was a condition on there. There was a condition, I believe it's out of this court, And there were two violations. The second violation report was ignition interlock.
Mhm.
But Mr. Dirkland did contact this court, actually got Norma Ferguson's email address and emailed her directly, trying to resolve the warrant to come in for a setting. This was the earliest we could bring him in.
Okay.
There was a vehicle. There's actually two vehicles. He's separated, but there was a person he was living with. And if I could swear him in.
Yes. And which court is the misdemeanor?
Well,
All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Dirkland Davy.
All right, so you're in this court for an aggravated assault with a deadly weapon. There was a allegation that there was a new case, which is a misdemeanor DWI, and that case is out of County Court 12.
It could have been the reverse also, because we appeared for County Court 12 first, and he
I
was not aware of this.
don't know
felony
anything
case.
about a assault battery with a deadly weapon. Deadly weapon.
No, here's the thing. We're talking about your conditions.
Oh,
You're in this court for an aggravated assault with a deadly weapon.
That is correct.
You have a misdemeanor case that's a DWI.
Yes.
The misdemeanor case with the DWI, due to that, I requested, or it was requested for you to have ignition interlocks. And according to the violation report, this is the second violation report. So what I did was I allowed you time to comply with the request for ignition interlock, and that wasn't complied with. So your counsel has some questions for you. You may proceed.
Mr. Dirkland, did you intend to violate any type of pretrial violation?
No, sir.
And is there a vehicle that has ignition interlock at this time?
No, sir.
And why is that?
Cause I don't have a vehicle. I've been on the breathalyzer for the entire time. The portable one, because I told them I didn't have a vehicle, so they scheduled me to have the portable, which I have here in court with me.
Did you at one point ever indicate to pretrial that there's a vehicle or one or two vehicles at your residence?
Never.
And there's a lady that you were separated from, but allegedly you're living together with her. Is that true?
Yes,
Does she have any vehicle to her name?
she has one, but I
You-
has no access to it. None.
Do you drive any vehicle?
No.
And the portable device, you've been regularly blowing into that as instructed?
Yes, sir. 5 a.m., 5 p.m., and 10 p.m.
Judge, do you have any questions for him?
No, state any questions? All right, so does the bondsman want to be on this case? I issued a judge's warrant. I didn't remand him. I mean, I didn't issue a bond forfeiture. So the question becomes whether or not the bondsman wants to remain on the case or be reinstated.
I don't have an answer for that. We would always ask for reinstatement. If there's an issue, we would ask for a PR bond, but I don't know if you could due to the nature of the felony offense.
All right, if someone, this is what the court will do. The court will reinstate or ask that the bondsman's bond. Well, no, actually, I don't have to do that. I just recall the judge's warrant, and if the bondsman hasn't filed an off bond, then that will be the bondsman. State, any objection to recalling the judge's warrant? All right, then the court will recall the judge's warrant. You will be on the portable device then. Do you understand?
Yes, ma'am.
And the court is going to state that there's to be no driving. Do you
No.
understand?
Yes, ma'am.
All right, is there anything else?
And just so you're aware, he didn't drive here today. He has family in the gallery that brought him to court, just so you're aware.
When I leave here, I gotta go take my drug test.
Okay, all right, the warrant will be recalled. You're not allowed to drive. All right, is there anything else?
Nothing further, Your Honor.
All right, thank you.
We can't discuss that with the judge here. Thank you, Judge.
You're welcome.
And Judge, the interpreter team.
All right.
Can you get rid of that?
Oh, I can't, okay, thank you. And there's that. Oh, let me put a date on that. At the top. Edgar Aguilar.
Hasta enfrente.
Megan and Davis.
All right, on this case, it appears we need a jury trial date.
That's correct, Judge.
All right, how long do y'all expect this trial to last? All right, Ms. Ferguson, I need a jury trial date, criminal trial division, 2 to 3 days.
Judge, I can do November 4th, but that would be an impact.
All right, it will be November 4th, impact court. Anything else?
Nothing further, Judge. Thank you.
All right, and I don't know if y'all can double check that an acknowledgement of discovery has been completed.
Sure, we can double check.
All right, thank you so much.
Good seeing you.
All right. Roberto Andrade. Who's the attorney for Roberto Andrade?
Check.
All right, hi.
Judge, I filed, after the last setting, my client had informed me that he wanted new representation, so I filed the motions. I apologize, just this very morning at about 8:30. They have been accepted.
Okay.
And so I'm requesting that he be allowed to, be appointed a different counsel. Our conflict has risen to a level where it appears that he doesn't trust me and
All right, do you have funds to hire an attorney?
Trying right on them.
All right, I'm gonna give you guys a jury trial date, and if he hasn't hired an attorney, then this is gonna be your attorney. And I'll hear your motion at that time.
Okay.
All right, Ms. Ferguson, I need a jury trial date for Andrade. How long do y'all expect this to last?
No more than a couple of days. It's
2 days?
Is there a family violence?
No, criminal trial.
I can do November 4th, Judge, as well.
All right, it'll be November 4th in impact court.
Okay.
And counsel, if y'all can make sure that the acknowledgement of discovery has been completed on him as well. You're welcome. Who's here on Francisco Sotelo Baez? All right. Christopher Weezer?
Present, Your Honor. Renee Munoz.
Thank you. All right, what is happening with this case?
Yes, Judge, the state has extended an offer. He's not in agreement with it. We'd like this matter set for trial.
All right. Your plea deadline date has expired. What that means is the court will not consider any plea bargain agreements without good cause. Otherwise, you'll have to plea open to the court. Do you understand?
Yes, ma'am.
All right, Ms. Ferguson, I need a jury trial date. It's family violence. How long are y'all expecting this trial to last?
2 days, maybe at the most.
2 days.
I can do that October 8th.
All right, your jury trial date will be October 8th.
Thank you, Your Honor.
Thank you, Judge.
All right, you're welcome.
No, CTV.
Norma, what date did we give? Oh, I see it. Otilio Espinoza.
Good morning. Mario Moreno. Yeah.
Counsel, you're on this side. All right. Is your client requesting a jury trial?
No, Your Honor, we are still in the midst of issues with discovery on this case with the
What
state.
issues?
There are two videos that are essential to this case in regards to the investigation that took place. I was working with the state at the last setting to get those downloaded, but we ran into some issues with it.
All right, what's
copying
the issue with the download?
When I received the copy of the video on a
Thank you, Bashan.
on a hard media, it was not able to play. I discussed with Mr. Edelman, and he said that you're gonna try another source of getting it turned over to me. But I still need those videos prior to discussing.
All right, when do you think you'll have the videos available for defense? All right, Ms. Ferguson, if you'll set this for the plea deadline date for the week of August 19th, please.
Yes, ma'am.
And it's Otilio Espinoza.
August 20th.
All right, August 20th.
Yes, ma'am.
There'll be no further extensions. Once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
You said plea deadline, correct?
Yes.
Thank you.
Eric Jones. All right, where are we on discovery?
We're still have some missing discovery in this case as well, Judge. It's basically all the videos, if any exist, including body camera and Copan for Mr. Jones.
All right.
I did discuss that with the state as well. They are reaching out to investigators to see if those can be made available soon.
Ms.
I have a request.
Yes.
Mr. Jones lives out of state, I believe, Missouri, is that correct? Getting here is a financial burden as well. If I understand we would need a reset, if at all possible, the court is willing to consider the longest length of time that the court is willing to give for a reset under these circumstances.
Well, he can appear by Zoom.
Oh, without work, perfect, Judge, if he's able.
All right, what's? And let me see what date. Ms. Ferguson,
Yes, ma'am.
on Eric Jones, can you put him for discovery at the end of the month?
Yes, ma'am. I can do August 27th.
All right, we'll set you for August 27th.
Yes, ma'am.
You can appear by Zoom. Here's the thing. When people appear by Zoom, you need to be dressed the way you're dressed today, which is appropriate for court, and you need to be prepared at 9. Do you understand?
Yes, ma'am.
All right. Once you sign the reset form, you're excused. Thanks for dressing appropriately for court.
Yes, ma'am.
And safe travels back to wherever you're headed.
Thank you, Your Honor.
You're welcome. Norma, what page is he on?
He's on page.
Thank you. Ruben Solano.
Ready.
Probation, this is an application. Court is calling 2024 CR 6514, State of Texas versus Ruben Solano. Can I have parties announced for the record for the state? Defense?
Deborah Burp, Your Honor.
And are you Mr. Solano?
Yes, Your Honor.
Did you review the discovery counsel with your client and have you received it all from the state?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Solano, did you review the document entitled Application for Community Supervision with your attorney?
Yes, Your Honor.
Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We waive it.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Solano, did you review the document entitled Court Admonishments with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Solano, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. There's a $2,000 fine. State recommends community supervision, and there's to be restitution to SAPD for drug testing. Did you understand that to be the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, your community service is to be for a term of 3 years. There's to be a TAP evaluation and 150 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
No objection.
State you may be excused.
Thank you, Your Honor.
Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We would like to.
Anything you wish to say on behalf of your client?
I hope you follow our plea agreement, Your Honor.
All right. When's the last time you had employment?
I was almost self-employed, so I work for myself.
Doing what?
I do, I'm a jack of all tradesman. I do plumbing,
Well, do you have a
mechanical.
license to do plumbing?
No, ma'am, I sure don't.
All right, so you
Yeah.
need to work on that
Yes, ma'am. So,
because then that means that you're dependent on people just calling you instead of a plumber
Yeah.
calling you.
okay,
How far did you go in school?
9th grade.
Why?
I had a kid at 14 years old, so I had to drop out of school and start working.
And when's the last time you saw your child?
My child been like 3 months, 4 months,
Okay. And how old is your child?
7 months. So 7-month-old baby right now.
Well, wait a minute.
What about?
My
you were
20-year-old.
14.
Oh, yes, yes,
It's
yes.
like
No, I'm talking about now. I'm talking about.
something's wrong with the.
No,
time.
I'm sorry. I'm sorry. No, I haven't seen my child like forever.
All right, so now you have a 7-month-old.
Yes, I got a 7-month-old baby. Yes,
And who does the 7-month-old live with?
with his mother.
All right. And who do you live with?
I live with my grandma.
All right, everybody always wants to put a bunch of problems on their grandmothers.
No,
You're an adult, get a job.
I know.
You know, live by yourself. Your grandmother just
Well,
wants to be a grandmother.
Yes, sir.
Okay,
Your Honor.
all right. Court is going to sentence you to 2 years in the state jail facility, suspended and probated for 3 years. $2,000 fine, that'll be probated. You're going to get employment, not this, I'm just a handyman. Not that there's anything wrong with that. Handyman is supposed to be a side job. You have your regular job and that's for extra income. So there's to be proof of employment within 30 days of release.
Gonna be in jail for a minute.
All right, well, I see in jail for a minute.
It's an assault case, not indicted.
All right. There's to be no employment as a home healthcare provider or with minors. We'll do the TAP evaluation in custody.
Okay.
Follow recs. There's to be no unsupervised contact with minors. There's to be 120 sober days. I'm sorry, 120 sober meetings in 120 days upon release.
Excuse me, will you repeat that just so I can understand?
120 sober meetings and 120 days upon release from custody. There's to be 150 community service hours. 50 of those hours will be waived upon completion of parenting classes. The remaining 100 hours will be waived if you obtain a trade school certificate or obtain your GED. Field visits 1 time per month for 6 months upon release from custody.
That means a home visit
Yes,
once a month for 6 months.
yes. Probation, is there anything else he needs? Oh, thank you. Regular reporting by Zoom or in person. And we're going to do the UA hotline until further notice. All right, is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. To be successful in this court on probation, communication is key. If you feel as though you're going to use, don't sit at your house and just think, oh, I'm going to use, I'm just going to see what happens. Pick up the phone, call probation, say, I'm struggling right now. They'll get you the help you need. If you feel as though they're not addressing it, you can always come back to court and I'll address it. Do you understand?
Yes, Your Honor.
Good luck to you.
Thank you.
Jocelyn Chapa. And probation, this is going to be the last plea. Who's on Jocelyn Chapa?
John Kuntz is your honor. I'm gonna stand in for him for the plea.
All right, did you introduce yourself to the court reporter?
Megan Enriquez, standing in for John Kuntz for Jocelyn Chapa.
All right, court is calling 2022 CR 2751, State of Texas versus Jocelyn Chapa. Can I have parties announced for the record for the state?
Engineer Saleman.
Defense?
Megan Enriquez, present for John Kuntz for Jocelyn Chapa.
And are you Ms. Chapa?
Yes, ma'am.
Counsel, have you received all of the discovery in this case and did you review it with your client?
I believe Mr. Kuntz has reviewed and signed it.
Court will find that the state is in compliance with discovery. Ms. Chapa, that you review the document entitled Application for Deferred Adjudication with your attorney. Did you understand it? Did you sign it?
Yes.
All right, you're gonna have to speak up.
Yes, ma'am.
All right, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand you're charged with possession of a controlled substance, penalty group 1 gram to 4 grams? That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Believe she has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Chapa, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $2,000 fine. State recommends deferred adjudication. They're taking into consideration 2022 CR 2752. There's to be restitution, if any, and 2022 CR 2752 to Derek Wilson. And there's to be restitution for drug testing to SAPD. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 5 years. There be a TAP evaluation, 200 hours of community service restitution, and no contact with Derek Wilson. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plea?
No contest.
State any evidence.
Contained in Exhibit 1 and attachments, Your Honor.
No objection.
All right, state, you may be excused. Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court would defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just briefly, Your Honor, on behalf of Mr. Coons, we'd respectfully ask the court to follow the agreement that Mr. Coons reached with the state in her case. And additionally, she resides in Amarillo, which I believe is Potter County. So we would respectfully.
sorry, which county?
Potter.
Okay.
We'd respectfully ask the court to transfer her supervision to Potter County if it is granted.
All right, do you have any children?
I do.
How many?
2 in Potter County.
And what are their ages?
23 months and 9 months.
All right, so why are you down here using meth when you have children?
That was back in 21 when I was using. I have not used since then. I've been clean and
It's been already 26 months that I've been sober.
Is Child Protective Services involved?
At this point, I don't think so, Your Honor, and that is something Mr. Coons did share with me, that she has been sober for almost 2 years. This case, the offense date of this case was, I think, about 3 years ago. And when she was arrested up in Amarillo, Mr. Coons got her brought to court as soon as she got to Bear County.
All right, and who has been taking care of the children?
They're dead.
And who is their father?
Matthew Laureano.
All right, you keep whispering. When people are in public, they don't whisper, but then when they come up here, they whisper. If you want me to hear your story, you have to speak up. Otherwise, I don't hear it.
Oh, I'm sorry.
So who are the children with?
Their father,
And who is their father?
Matthew Laureano.
And when's the last time you had employment?
I've been a stay-at-home mom since I've had my 2 kids.
All right, this is what the court is going to do. There's a $2,000 fine. That will be probated. 5 years deferred adjudication, take in consideration 2022 CR 2752. Restitution, if any, and 2022 CR 2752. To Derek Wilson, restitution for drug testing to SAPD. There's to be no contact with Derek Wilson or Jeremy Joe Alcaraz. Regular reporting by Zoom or in person. There's to be regular random UAs. She can transfer to Potter County. I'm going to require field visits. I don't know what's happening with the children or what's going on. So I'm going to want field visits 1 time per month until further notice. There's going to be 200 hours of community service restitution. I'm going to order parenting classes. Once she completes parenting classes, that will be deemed satisfied. How far did you go in school?
I graduated high school.
All right, what are you planning on doing with the rest of your life? I know you say you're a stay-at-home mom, but when there's an empty nest and they start school, what are you doing? Because at some point they're going
Yeah.
to start school.
Yeah. Well, I was going to school for accounting. That's what I enjoyed doing.
All right. Well, let me do this. Probation. I will deduct 100 hours of community service restitution upon completion of parenting classes. And then the other 100 hours will be waived if she could obtain some sort of trade school certification. Otherwise, if you don't, you're going to be required to do parenting classes. As far as the trade school certification, you can do that or do the community service hours. Do you understand?
Yes, ma'am.
Probation, is there anything else?
Are you making her get a job at this point or no?
Well, I know that childcare is expensive.
Right.
And she's saying she's a stay-at-home mom, but I do have concerns for the children. I know she's telling me that she's clean, but since she's not going to be here in Bear County, I can't do the testing the way I normally would do it. So that's why I'm just going to want them to do those field visits 1 time per month until further notice. All right, thank you. There'll be 120 sober support meetings and 120 days, and they actually do those online. Is there anything else? Is there anything else you need from the court to be successful?
Oh, she just wanted to share with the court that the reason she moved to Amarillo is because the people that she was associated with in San Antonio, that's when she was using, and she doesn't have the same friends and
Yeah.
associates in Amarillo.
We moved to Amarillo and that's why I got clean. And I
All
stayed
right.
away. That's, yeah.
All right, well, I'm glad you found a way to be sober.
Stay
All
away
right.
from here.
Okay, all right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, yes.
Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you. We can go off the record. In this court, to be successful, communication is key. If there's an issue, let probation know. If you feel like they're not addressing it, you can always come back to court, okay?
Okay, thank you.
All right, thank you.
Thank you, Your Honor.
There's a song, I think Amarillo by Morning.
Yes.
All right, counsel, yes. Yes. And you have Sandy Garcia? All right, Deputy Lawyer, Sandy Garcia already has warrants in this case, is that correct?
Oh, on her?
Yeah, I don't know if he might be doing it right now.
Your
Is it this one?
I'm doing it.
Sandy Garcia,
I forgot he does it.
she has warrants, correct? She doesn't? All right, could I have a prosecutor? Court is calling 2000.
She's here.
Oh, where's Sandy? Oh, okay, oh, yeah, what's happening?
She's here.
Okay.
I've done it off the prosecutor, but I just got appointed a couple weeks ago. I'd like to.
Sandy Garcia, come forward.
Mr. Attorney, what's your name?
Attorney Michael Collins.
All right, hello.
How are you?
I'm doing okay, how are you doing?
I'm fine.
All right, so here's the thing.
Remember me?
I'm sorry?
Remember me?
Yes, I do. So here's the thing. You got to make sure that you're on time for court.
I was just told today by him, he called my lawyer.
Well, no, the only thing is like you had a previous court date, so I had it recalled again for today. And I'm giving people a slight pass because of Odyssey. So you're gonna get a reset form. Make sure you're here and on time, okay?
Okay, it just, I wasn't even aware of the first.
No, we're starting where we're starting now. I'm just letting you know. Miss Ferguson is gonna give you a reset form, so you need to make sure you're on time, okay?
And
All right.
Address too.
Miss Ferguson,
Yes, ma'am.
can I get a 30-day reset, please?
Yes, ma'am, I can do August 26th.
All right, we're gonna set it on August. You don't have to remember it. She's gonna give you the reset form, so you'll have it.
As soon as I was told to come, I just came. So-
Okay, no, I'm glad you're here. All right, so we're gonna be back on August 26th, and defense, you may want to see if Esperanza Court would be willing to accept her. Hmm?
I'll do it again.
Yeah. Counsel? You may want to see if Esperanza Court will be willing to accept her. Miss Ferguson,
Yes, ma'am.
if you can do a referral
Yes, ma'am.
for Esperanza Court.
Yes, ma'am.
And what page is she on? I see.
4 and 5.
Okay. And you need to make sure you stay in touch with your attorney,
Yes, ma'am.
because this referral to Esperanza Court, they will want to reach out to you, okay?
Yes, ma'am. I'll just let him do it.
Okay,
Thank you.
Yes, thank you. Who's here on Francis? Oh, you, after you, yes. Who's on Francisco Sotelo Bias? All right, what's happening with this case?
Yeah, we have plea paperwork, Judge. There's been some complexities with this case. Been some Padilla consultations that have been ongoing this morning. I was just sent a letter via email.
Okay, so we'll have to do this probably later in the day. Can't do it right now,
Okay, Judge. Well, I still.
because I don't have any paperwork.
Correct.
Okay, so we'll be back this afternoon. Hi. All right, they're gonna end up taking him back. We'll bring him back this afternoon. Sarah Gutierrez. All right, today is plea deadline date.
Yes, Judge, there's still a plea available for Ms. Gutierrez on the table that she is interested in accepting.
All right, the
but-
plea is today.
But the issue we run into is the cases that she would be pleading into are still pending filing for the DA's office. I've tried reaching out to them to discuss
Who is the prosecutor for that? The cases that are still,
the one that we're here for today.
no. The cases that you're saying that she needs to plea on that will solve this case, are those other
There's a-
cases misdemeanors? What are they?
There's a misdemeanor that the DA's office is potentially looking into filing as a felony. So I've been in discussion or trying to reach out to the intake prosecutor in that regards about if indictment is going to occur, so we'll move forward with that one, or if we can move forward. It's just, there's a lot of background issues that's preventing Ms. Gutierrez
All
from
right.
actually accepting the offer.
All right, let me just tell y'all, this is the last date, and whatever happens with that case, then that's out of the court's control. The last date on this case for a plea deadline date is gonna be August 12th. Everything needs to be in place by August 12th. If it's not, then this case is gonna be going to trial.
Yes, Judge.
All right, Ms. Ferguson, on this case, set for August 12th, please, final plea deadline date,
Yes, ma'am.
and it's Gutierrez.
I'm sorry, Judge, what was that last?
Oh, sorry, it's August 12th.
Thank you, Judge. And she's excused after signing?
Yes,
Thank you, Judge.
you're welcome.
Need her email address.
Anthony Villarreal.
Mr. Villarreal.
Family violence thing.
I don't think so.
Is this family violence criminal trial division?
Criminal trial.
All right, what is happening with this case?
Judge, the state is, we've been conferring, they've been trying to get a hold of the complainant, they've been playing, phone tag, I guess. This was reset just like 2 weeks ago to get a hold of them,
Okay,
and we're still kind of in that loop, but I think they're kind of closing in on it pretty soon. The guy actually made contact back, I'm understanding. They just haven't talked to him.
He contacted back, judge, contacted him again, it's one of those things.
all right, how much time are you all asking for?
I mean, a couple weeks, Your Honor, and
All right, Ms. Ferguson, on Anthony Villarreal, can we recall this in 2 weeks, please?
Let's see.
I can do August 13th.
All right, we'll be back on August 13th. Thank you for dressing appropriately for court. Once you sign the reset form, you're excused.
Thank you, Your Honor.
We have to do the 13th.
You have to ask for that.
Okay.
So they want to move it from August 13th.
I could do the 14th. I mean,
No.
it's a little bit,
No to the 14th.
okay.
It's either the 12th, the 13th, or the 15th.
For the 15th.
All right, Ms.
I'll do the
Ferguson,
15th.
you put it on the 15th?
Thank you.
You're welcome.
Yeah, right?
You can,
That's-
maybe his email address.
All right, everyone, we are taking our break.
Judge, that was for a plea deadline?
No, the state needs to speak with a witness. All right. And we'll be back in the, probably